Daily list for orders item 1.
This reference, my lord.
उसके बाद ये आ गया क्या बोल रहे हैं ये जगह हमारी बात
Kita bukan, ini sih nang, orang ini belum. Kita bukan ya, ini sih.
यहाँ में बोल रहे हैं
Yes, my lord, already this issue, my lord, come up for the various high court. Almost 7, our high court is now 8 high court, my lord. Already, my lord, 7 before the 7 high court. That was, my lord, that issue was come up, my lord. Only Rajasthan High Court, my lord, give a different view. Other 7 high court, my lord. I'm giving a, my lord,
That is Punjab, Haryana, Allahabad.
Punjab, Haryana, Allahabad. And Punjab and Haryana High Court judgment is, my lord, very, was discussing all the point in the previous law also, my lord.
Punjab and Haryana, Allahabad,
Allahabad is the division bench judgment, yes.
Kerala also.
No, there is no, my lord, there are 6 high court, Kerala High Court, Delhi High Court, Bombay High Court, Allahabad High Court, Punjab and Haryana High Court, and recently in the Meghalaya High Court also. So they express their same view, my lord, that it will be BNSS, not CRPT. As the answering the reference only, my lord. So our reference is only bail, revision and appeal regarding pending cases. So that's why, my lord, my submission, when I am fully agree with the judgment passed by the Punjab and Haryana High Court. Has very elaborately, my lord, discuss everything, my lord.
My Lord Justice, they passed the judgment. By coincidence, I was there. So I had the occasion to address, although it was quite impromptu. And I am fully in agreement. In fact, my Lord, if you lordship come to the section 531 of the new act,
Yes.
subsection C of throws light on the intention of the parliament.
Yes.
Your lordship kindly comes to 2C.
Yeah.
Notwithstanding such repeal, C, any sanction accorded or consent given under the said code, in pursuance of which no proceeding was commenced under the code, shall be deemed to have been accorded or given under the corresponding provisions of this Samhita, and proceedings may be commenced under this Samhita in pursuance of such sanction or consent. This also throws light on the intention of the parliament, that it should be under the new act.
Otherwise, also this 2A is very clear.
Yes, sir.
Who is
It
here?
speaks about only pending.
Pending.
Yes. Anybody else?
Or on behalf of state of Assam, I'm appearing on behalf of my lord, Local General, my lord. We have already complied with my lord under the process of the new PNSS. We have a memorandum, my lord. We have already, we have to follow it, my lord. Gujarat High Court, Gujarat High Court, 1974.
itu panggalan bisa itu 64 look with me. You are asking that. 7.
Basically, this is regarding registration, Lordship. Now the case is whether the bail application and other, I have gone through all the judgment, Lordship. I found one judgment of 1974 of the full bench of Gujarat. Identical provisions of savings were there, 1974. SCC online Gujarat 65.
Yes.
Here the honorable court says that saving provision is more or less identical. At that point of time, whether the earlier CRPC or the 1973 CRPC will be considered at the time of filing an appeal. And the Honorable High Court of Gujarat said that the case has to be considered in terms of the previous law, because this is a procedural law. So that judgment also I'd like to place, Lordship, but these are the two conflicting areas, Lordship, now. So finally, whatever Lordship directs will follow.
The only question is, even though if the FIR is registered prior to 1/7/2024.
Yes, Lordship.
But subsequently, after 1/7/2024, any application,
Lordship.
either under section anticipatory bail application or regular bail application is filed, that is to be filed under which section?
That is what I am trying to say, because if we look at the savings clause,
Yes.
it is very clear that the pending applications. Now, the pending applications, as my Lord Justice Ete has, if we look at the word 531,
Yeah.
2A,
Yes.
the code of CRPC 1970 is hereby repealed, notwithstanding such a repeal, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, and investigation. These are the five events, Lordship,
Yeah.
pending. That pending word is also having significance here.
Fine.
Then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as the case may be in accordance with the provisions of the CRPC 1973, as in force immediately before such commencement referred to in the said code, as if this Sanhita had not come into force.
Fine.
Now, a bail application, Lordship, whether we can consider it as a part of inquiry or investigation or trial also, because that is the area,
As you have mentioned, investigation pending.
pending.
So if the bail application is not filed prior to that, 1/7/2024, in a case registered prior to 1/7/2024,
Lordship,
it can't be treated as a pending.
my submission is that pending application of any appeal application. Application is one part. Trial, inquiry, and investigation. Whether this bail application or suppose there is an appeal we have to file. Under what provision it will come? That Gujarat High Court says the appeal will also have to be filed under the previous law. Because all the rights were active under the law which was applicable at the time when the case was registered.
Please supply us a copy of that judgment.
Judgment, Lordship. I could not make, it is on the process of extra copies, Lordship. Did they come? Kerala. That's the problem. For tomorrow. Hmm? Yes. Kerala person. Unta. ಈ ಪ್ರಮಾಣ detail argument ಕೊಡಿ ಆಯ್ತು ಎರಡು ತಿಂಗಳು detail argument young लोग होंगे तो हम उनको स्टेप more problem है I do. Any If we look at the law, trial is temporary spending, investigation is spending. Reasonable काम करता है। Reasonable depend हमारा ಇದು ಪಂಜಾಬ್ है तो most money we are discussing all that ಪಂಜಾಬ್ due to itu udah pattern है केरला केरला 14 itu prefer for us like what kursi kursi replay people itu pun pernah ini kan itu ini udah pernah ada mau buat tuh dia tetap dana mau kita ya pokoknya kontak itu kan buat kita tuh kontak এলাকাতে কি করবেন নতুন মতো করে বলুন না প্রোগ্রাম
Mr. Advocate General,
লর্ডশিপ
here this Gujarat High Court has taken a view, taking into consideration the proviso to this 484
Yes.
1A.
more or less the same language is
Language is not same, the proviso is not here, it is missing here. It is missing here. And then the Gujarat High Court went to this extent that since, or there is any restriction in the new, this PNSS, is there any restriction in filing of the appeal or not?
there is no
No restriction. Here they have make out a difference that there is a, in the new code, the right to appeal is restricted, whereas in the old code, the right to appeal was there, the person having two opportunities to file an appeal. That is there. That's why only
However,
this,
this judgment was considered by Kerala and give a contra view in Kerala.
in this latest,
Yes,
Yes.
Abdul Kader.
Yeah. that has been delayed.
But this judgment was also considered. ঠিক হলে ultimately clear one and one. Will be continued in investigation. Pending indication. In the cognizance is taken. They will be continuous. Now, another judgment, Lordship, which is very recent of the Allahabad High Court in paragraph 16. State of issue versus,
Mr. Advocate General, you are referring to Deepu?
yes, paragraph 16.
Is the-
Segregated various stages
Yes,
of the investigation as well as the trial.
yes. Okay, it is the only nominal therapy.
Yeah, that's what I'm asking.
Yes,
So this is from our side, Lordship, whatever Lordship decide, we are going to follow.
anybody else?
Still in a very fluid situation,
Will clarify, try to clarify.
Lordship, yes. Highly obliged, Lordship.
May I please, your lordship? I am appealing on behalf of state of Mizoram, lordship. I have prepared a small submission, lordship. I want to submit, lordship. I fully support the judgment passed by the Allahabad High Court, lordship, specifically paragraph 14, 15, and 16, lordship.
Arguments heard? Judgment reserved.
Adjournment request, if any, from item number 1 to 7.
May it please the lordship, I beg to mention item number 2, lordship, with the consent of the other side. Lordship, affidavit of respondent number 6 has been sent for vetting, lordship.
Item number 2.
Lordship. Affidavit is ready and is been sent for vetting, lordship.
Adjourn.
Lordship, 2 weeks, sir.
From item number 8 to 20.
May I please, lordship, I beg to mention item number 20, lordship.
Yeah.
The Angus council is physically not well, lordship. Kindly adjourn the matter.
When, madam? When?
After 2 weeks. 2 weeks.
There's nothing in this. Compassionate appointment. Matter. The learned single, there's a blood upon Devashish, this. Devvrat Tiwari, Supreme Court judgment. After good number of years have passed, the financial hardship, when was diluted. Only 1 week. 1 week.
Oh, bless.
Fix the date.
13, 11.
Item number 11 and 12, my lord.
Yeah.
Before the Honorable Read Court, my lord, there was an order by Honorable Justice UK Nair not to be listed. This is a matter regarding Jorhat Science College matter.
Another bench.
May I please, your lordship, lordship, item 13. Item 13.
1-3, yeah.
1-3. Lordship, this item, Advocate M. Datta's name has not been shown. So we have missed the item, lordship. Lordship, may kindly
Whose
adjourn.
name has not been shown? aviator. Just after 2 weeks,
Lordship, M. Datta's name should be shown.
while reflecting the name of Mr. M. Datta as counsel for the aviator. Yes,
My lord, this is a state appeal, my lord. I have informed them because my lord name has not been shown in the cause list, my lord. May I pray, my lord, to list this matter on next Monday, my lord.
this matter shown. Yes.
Right. All right.
Item number 25. My lord, we need to file reply because appellant file an additional affidavit. My lord.
You want to file in
10 days, my lord. Just 10 days.
another bench.
May please your lordship. I beg to mention item number 21, my lord. The learned counsel for the petition, Mr. A.R. Bhuyan, has undergone lung surgery and he is now under treatment. My lord, after 3 weeks, my lord.
Okay. Counsel appealing for the appellant has submitted that arguing concept Mr. A. Bhuyan has undergone exceptionally recently. And therefore matter may be adjourned just after 3 weeks.
Highly obliged.
My lord, with the consent of the respondents, I am praying for an adjournment in item 32, my lord.
22.
32, my lord.
Adjourn,
Can it kindly be after 2 weeks? Ma'am?
adjourn.
Much obliged.
May it please your lordship. My lord, item number 30 may kindly be taken after 4 weeks, my lord.
3-0
Please, your lordship.
hearing.
Yes, lordship. The leading counsel is bedridden due to fracture of his legs, your lordship.
Adjourn.
Obviously.
But with the consent of other side, I beg to mention item number 22, lordships. The matter will be taken after 4 weeks, lordship. Can
Why?
be, it's the engaged counsel of Kolkata, lordships, because of personal difficulty on his part.
Adjourn.
Can it be fixed on, lordship, 10th of December, lordship?
Adjourn. Yes.
May I please, your lordship? With the consent of the opposite side, lordship, I beg to mention item number 33, lordship, for adjournment, lordship. It may be listed after a week.
Adjourn.
I'm obliged.
Any other request?
May I please, lordship? Lordship, I beg to mention a matter, writ petition 5565, lordship, for listing, lordship. Fresh matter, lordship. May I kindly take up on Wednesday, lordship?
What's the urgency?
Lordship, the matter was filed on 22nd, and thus, apart from that, also there are some urgency laws.
Matter pertains to what?
Matter pertains to repealing of the Act of 1935, that is the Assam Muslim Marriage Register and Divorce Act. And there are some recent developments as well, lordship. So a fresh matter, lordship.
Matters are pending already.
Lordship, in this matter, some recent developments have also been incorporated and some,
When those
lordship,
matters
here
are-
the
when those matters are fixed. There are 4 or 5 petitions. When those matters are fixed. We'll list along with those matters whenever those matters are going to be listed. Because there are 4 or 5 matters are pending. List along.
But lordship, if permit, lordship, in this petition, some new developments have also been
Whatever, we will take into consideration those new developments also.
obliged, lordship.
Yes.
Daily list for orders item 1.
So office note indicates that neither the answered notice or ID card has been returned back
When the notices were issued.
on 16/2. Earlier notice was issued that didn't appear, the appeal was admitted. After admission, we took fresh steps.
You have not taken the fresh steps.
Yes, we taken fresh steps on 16/2 lots.
16/2, yes, that's right, but still,
There is a office note of 25/10.
yeah,
Neither the,
take fresh steps.
Yes.
The notice issued to the sole respondent
sole respondent.
remain unserved. Seems long, stop. And it once it for the appellant is directed to take fresh steps for service of notice upon the respondent within a period of 1 week on taking such steps registered AD and trustee.
But the trustee will be different because he is from Bombay lots. Will take registered post.
8 weeks.
No.
8 weeks, returnable 8 weeks.
Item 3.
Research করি এনেকে দিতে
Yes.
My lord, I am only concerned about the delay in dispersing the scholarship. So if we can, if your lordship can identify the reason for delay, the people will be benefited. That is all. My lord.
But this is the list wherein you have,
No,
this, how
if-
many beneficiaries are 200?
Uh, At least 15 beneficiaries we have given here. In page number 80 in the additional affidavit, my lord,
Why these persons are not able to approach this court?
even individually.
Individually, or
Individual.
whatever it may collectively by filing a writ petition?
My lord, these
Why
people,
this PAL petition?
my lord, they are from a downtrodden and very poor
Where-
background.
Where you have mentioned that these people are not able to approach the
Okay,
court
yes,
on
ma'am.
account of their whatever incapacity or whatever it may, how they are incapable of?
Due to lack of sufficient fund, my lord, for that.
Where you have mentioned in the writ petition, this, our rule says, this PIL, rule says, you have to indicate the reasons for that.
So that I have indicated somewhere, my lord.
Where is that?
Hmm?
You have to mention it in para number 3.
Yeah. Economically downtrodden people as they are incapable of assessing
Reason.
this honorable high court. The
And
petitioner is filing this.
everybody, when they have approached this Canara Bank,
They have approved Canara
on which
Bank, my
date
lord.
they have approached, sir? This cyclo-style application,
Yeah, my lord.
all the persons are
My lord.
filing the same application that we have approached,
Yeah.
and they have failed to upload that. Can it be?
No, your lordship will
Material
kindly
manner?
see 81, page number 81.
Yeah.
There they have given their, my lord, detail,
81,
yes.
yeah.
It, then your lordship will go to 82, 235. This
Yeah.
is Rupjuti Bordoloi.
Yeah.
Then his father's name is so and so, mother's name is so and so, Assam. They are pursuing MA in economics. Then your lordship will go to 88, page 88, at serial number 137. Page 88, Farhan Sultana. This is Assam, MA education in this college. Then your lordship will go to page 91. 84. Serial number 84.
Within how much time these persons are supposed to apply for this?
Within 2 years.
2
They have gone there, but they have.
When they have gone there, sir? Kindly consider their, whatever their application or. Page number 80,
Yes.
or, sorry, 83 or 80, yes. 80,
80.
yes. 28/5/2024.
Yes, ma'am. In the broader sense, my lord, these people has been given, they have been
Sir,
selected by UGC, my
Sir,
lord.
you have to come out with a case.
My lord, only thing,
If
my
you have
lord,
applied
they are
after 2 years,
facing some difficulties.
sir, if you have applied.
They
after
cannot
2
come, my
years,
lord, by their own. So they have approached this institution.
But ultimately, there is a time limit.
Time limit is there, no doubt, to
Then
200.
they, first they apply for that within, whether they approach within that time limit or not.
They have approached the Canara Bank in time limit several
Where is
times.
that, sir? You please read this page number 80. This request to take necessary step of disbursement of sanction scholarship amount. Sure. Sir. Accordingly, I approached to the nearest designated Canara Bank branch, but approached designated branches unable to load the document disbursed in manpower or
My lord.
technical and untrained, etc.
And-
Also, I approached an institution, but institution unable to upload the documents for the reason 24 months time is already over. Then what's wrong in that, sir? when they approached the Canara Bank, and when they said every person the same representation, same,
My lord,
verbatim same.
they went to our office there.
When?
They have given
Whether they
in
were approved
80.
within 2 years or not?
Okay. Within 2 years they have.
Where is that, sir?
That, the date 28/5/24, page 8.
This is what they have sent you a letter. As you claim that these candidates have written a letter to the Mumtaz Foundation. And this is what the letter, everybody has written the same letter.
My lord.
It says, how can it be?
Anyway, my lord, in broader sense, if your lordship,
Broader sense,
please,
at least, sir, for the
that
purpose of
to identify the
creating a- there
reason
must be
for
some-
this
we should be
people,
satisfied.
they have been given, they have been selected. They were pursuing their MA, MPhil. If they get a notice, my lord, they will say the difficulties they are facing in releasing the money in time. If that can be identified, my lord, for future also, that will be
We are
help.
not satisfied with this, whatever contentions you have raised. In general, you have this leveled allegation in that they are not getting it. When we ask for better particulars, you have simply said, when they have approached, if the person has
That- that-
approached
that is
after
correct,
the
ma'am.
timeline, how can we expect that their application has been proceeded? How can we expect, sir? When there is a
And
timeline.
that is what we could do and we have done and we place with your lordship for consideration. If your lordship feels that the scholarship may be disbursed in time. If they say this is the difficulties we are facing in disbursing,
We'll pass it on.
mine. Obligement.
Goes for all.
Item 4.
Respondent number 6 and 7 has not been served.
My lord, service is the service report.
Yeah.
The service report, my lord. Service not completed.
Return of notice of respondent number 6 and 7 for 3 more weeks. 4 more weeks.
Item 5. Today it speaks for file counter affidavit for the respondent. They will take.
Below 212 this morning. 227 was supposed to file an affidavit.
They will inform us to take, they will take 1 week for
Nobody has filed affidavit.
file counter affidavit.
Lordship comes to page 7, paragraph 4. That is their only ground.
Yes. What is your grievance about the judgment?
Plus, there is another thing.
The learned single judge is rightly said that till you are entitled for the salary, till your term is expired, that's all.
Yes, my lordship.
24, 25, 26.
I should pass over for timing. My senior is another court.
Pass over. Why?
My senior is.
Pass over for the time.
Item 6. I'm being.
May I please, my lord? My lord, there is a delay of 278 days, my lord, in filing the connected appeal. My lord, the
Yes, what do you want?
My lord, I hear the delay which they have praying for continuation. It has not been explained in details. And then it's not 278 days, it's 308 days delay. And then in between, my lord, they have filed an IA, but it has been kept in defective on defective for 94 days and which has not been explained at all. The process that the respondent. Well, the process that respondents, the appellant, they have taken up is that in a very leisurely way. That they have exhausted the responsibility that they have to be taken up. That's the prayer.
The matter comes upon for consideration of the IATA pursuant so with a prayer to condone the delay of 270 days in filing the connected appeal. Full stop. Affidavit in opposition is filed on behalf of the non-applicants, contending that in fact the delay is not only 270 days, but it is more than 300 days. It is also contended in the affidavit that the delay has not been satisfactorily explained by the applicants, and therefore no case for condoning the delay in filing the connected appeal is made out. Having heard the learned counsel of the party and after going through the contents of the application under section 5 of the Limitation Act, as well as the counter affidavit filed on behalf of the applicants, non-applicants, we have the view that the delay in filing of the connected appeal is liable to be condoned, hence IA number so and so is allowed the delay in filing the connected appeal is condoned. Registry is directed to register the connected writ appeal and and listed for admission after 2 weeks. Yes,
Item 7.
May it please your lordship.
fresh,
May it please your lordship.
fresh. It's a fresh.
Yes, your lordship.
You're appealing, Mr.
For the department, I'm
It's a condemnation of delay, your lordship, for 81 days.
Yes, 81 days. What do you want to do?
In fact, I have not received the copy, my lord. Just.
What is the reason for delay?
My lord, the applicant was not well, my lord. He was under medical, my lord. The prescription I have annexed in last page, your lordship.
Is you certified that 60 treatment of? What is this treatment?
My lord, he was not well, my lord.
Treatment for ding? What is this
Lordship.
illness?
Bed rest, my lord. He was in bed rest, your lordship.
Yeah, better, that's right. But treatment for, what is this treatment for?
Beauty, PVS.
Underway treatment for, what is this disease?
He was young one.
What is this disease?
My lord, it's in some medical term, your lordship. I am aware.
Yes, Mr. Nath.
Lord, as regard condemnation of delay, I leave it to your lordship.
The matter comes upon for consideration of the IEA. Referred on behalf of the applicant under section 5 of the Limitation Act with a prayer to condone the delay of 81 days in filing the connected appeal. Full stop. Mr. Nath is appearing on behalf of
1, 2, and 5, 4, my lord.
I'm got fine. I counted.
1, 2, and 4. Who? What about 3?
3 is, my lord, finance department, my lord. Lordship, may record the name of Mr. B. Gogoi, my lord.
And this treasury officer, Lakim,
Same, my lord. Mr. B. Gogoi here.
Mr. So and so. Put in appearance on behalf of the Mr. Nath put in appearance on behalf of the respondent of 1, 2, and 4. Mr. So and so is appearing on behalf of the respondent number 5. Mr. So and so is appearing on behalf of the respondent number 3 and 6. Stop. Having heard the learned concept of the parties and after going through the contents of the application under section 5 of the limitation act, we deem it appropriate to condone the delay of 81 days in filing the corrected applicants. IA number so and so is allowed. Delay of so and so days is condoned. This day is directed to register the connected appeal and listed for admission after 3 weeks.
Deeply object.
Item 8.
Yes.
Lordship, so far as this case is concerned, your lordship has already stayed the impugned judgment.
Well, admit it here.
Right.
Admit this matter.
In that case, your lordship may fix a date for final disposal, your lordship, because your lordship
Having
ultimately.
heard the learned counsel for the parties, we are of the view that matter requires consideration, hence admit no need to issue notice, no need to issue formal notice as parties. Respondents are represented through respective concerts. List this matter for hearing in due course in the month of January 2025.
Otherwise, your lordship, the issue is very small, your lordship.
Very small.
I have not been exonerated by the honorable single judge, your lordship. Only thing, your lordship, proportionality, your lordship. That's the issue.
And the loss of confidence.
But your
One of
lordship
the
will
aspects.
your lordship will kindly see, your lordship will see that your lordship, so far as this person is concerned.
Well, here, that's what
Lords.
only we have admitted.
Lords.
It's a-
Item 9.
Like,
Also, this matter. I don't know this one.
Yes.
My petitioner has challenged an order as old as of September 2023. Certainly, my
Maybe you have uploaded it after so many months.
true, my lord. For that
I'm
matter,
not
I can
aware of that.
I can definitely file an affidavit to that effect, my lord, justifying on merit. But before that, my lord, the Honorable High Court rule, my lord, on PL says there has to be a statement made in paragraph 6 regarding representations filed. He has not filed any representation, and my lord,
Once you have denotified it,
Ready. And
what
there
is
is
the
a
use in, what is the use in filing the representation?
there is a judgment to that effect, my lord, that this is binding.
The appellant that the government is contemplating to withdraw this or denotify this forest, the reserve
Yes.
forest area, and therefore he moved and representation, it is not the case.
But
You
on,
said it.
on merit, my lord, what they have said, my lord, that. Is it? Also, there is a clear cut violation. On merit, my lord, what they say, that section 26A will come into effect and we have to take concurrence from the National Wildlife Board. That comes into effect when the notification, final notification of wildlife sanctuary is notified.
No, your lordship.
Yes.
There are clear orders of the apex court, your lordship, honorable apex court.
My
They
lord,
have
kindly
annexed it, your
schedule Wildlife Protection Act for a
Why
lordship.
not reply whatever?
True.
Why not reply?
Well, fine. Otherwise, my lord, there is a judgment of division bench, my lord, that this rule 6 of PIL rules is binding, my lord.
We'll consider it.
I'll file on affidavit.
Issue notice, Mr. So accept notice on behalf of the respondent.
I am for 2, 3, 4, 5, and 6, my lord,
2, 3, 4, 5,
and 6.
and 6. Okay. So respondent number 2 to 6. Yes, Mr. You are appearing. So and so is appearing on behalf of the respondent number 1. Hence, no need to issue formal notice to the respondents. Full stop. The consent of the respondents praised for and granted 3 weeks time to file counter to the PIL petition. This after 3 weeks.
Deeply reversed. No. Obliged.
Item 10. May I please, your lordship? This case, your lordship, very limited issue is involved, your lordship. Where that a delimitation of the constituencies, your lordship, has been done, your lordship, and the
Court have- You have to answer two questions.
lordship,
Is there any violation of statutory rules?
lordship,
Or you have alleged malafide?
lordship. No, your lordship, I have not alleged
Then
malafide.
we are not going to. enter.
Only one aspect, your lordship, will kindly, I want to
Only this
point out.
SOP.
Lordship, SOP, your lordship. That is the
SOP.
only case my,
SOP has any statutory force?
your lordship, that SOP, your lordship, says, your lordship.
Is it statutory, having a statutory force?
Lordship, apparently it is not, your lordship. It is not, your lordship, statutory, but the
So far as regarding this fixing of headquarters, etc.
lordship, I
It is in
understand
the
that.
domain of the executive.
Lordship,
How we can apply-
absolutely, your lordship. I know, your lordship, that that has come from your lordship now. But your lordship, only issue is that SOP, that since they have issued an SOP, your lordship, there must be something.
Is it enforceable? Statutory force?
But your lordship, they have, your lordship, on the
Yes, so far as they has to follow it, not in this.
lordship,
Instead-
and in fact,
the
your lordship,
court is
that
not supposed to interfere in this, enter into the domain of the executives.
unless your
It
lordship,
is-
unless your.
It is.
Unless this SOP is there, your lordship, I would not have come before this honorable court, your lordship.
That-
But only thing, and that SOP, your lordship, that in case of existing block is divided among two, then your lordship, priority to use the existing block headquarters within LACs as the headquarter of new reorganized block as far as practicable, your lord. This has been since 1991, this has been there, your lordship. Now they are trying to take it to some place, your lordship, ultimately, which is, your lordship, threatened by erosion, your lordship.
This, so in that area, in that village or whatever it may be, you mean to say that no facility should be made?
No, I am not saying that, your lordship.
That seems the land is compromised or whatever it may
Lordship.
be. The incident of land erosion are there, therefore there should not be any construction of headquarters.
And a purpose for this is to, your lordship, save money from the public exchequer, your lordship. Since it is already existing, the infrastructure is there. What is the necessity of, your lordship, shifting it to some other area, your lordship? And that is why this SOP says, your lordship, that this, as far as practicable, your lordship.
As far as.
As far as
As
practicable,
far as
at least,
practicable,
your
it is
lordship.
for them to decide whether it is practically possible or not, or it is as far as practical is it is practical or not.
At the end of the day, your lordship, these, your lordship, these issues, your lordship, involves, your lordship, interest of the people also, your lordship, public also.
So you
Your
mean to
lordship.
say that the interest of these villagers of Chitrakoot or what is this place name is?
Chirakuti is the present place. your lordship.
People may be interested in that, but the where the headquarters is fixed, those people are interested in getting this headquarter fixed at their place. Is there?
If your lordship, they can go by, your lordship,
Interest
but
of two two residents of the area is there. So court is nobody to interfere into.
lordship, I understand that, your lordship, but only thing, your lordship, since they have an SOP, your lordship, they have done everything as per the SOP, and SOP, your lordship, laid down certain things, your lordship, to be done in a certain manner, your lordship. That's my case, your lordship. They have not followed it, your lordship. And why they have not followed it, at least that they may disclose to this honorable court, your lordship. Why they have not followed it. If your lordship satisfies that,
So
yes,
in
this,
each and every case, we can't, then they have almost fixed these headquarters for with this notification of 10 places.
lordship.
How can we interfere? in
Lordship,
all
that's
those
why,
10?
your
They have
lordship.
to furnish explanation for every 10 places.
No, your lordship, not for everything, your lordship. Not in case of every place, your lordship, the people are before this honorable court.
We know our limits.
Only in this case, your lordship, people are.
Mr. Lord Thakur, we know our limits. These are purely the matter in the domain of the executive.
Lordship,
This is not for the court to
Lordship.
decide where the headquarters is to be fixed or not.
lordship,
That is purely
lordship, it is
administrative.
there, your lordship, but only thing, your lordship, since a existing infrastructure is there,
File a
it is functioning
representation,
properly.
File a representation, then consider your thing. at the best, this relief
That we have already filed, your lordship. That is, we have annexed, your lordship.
get-
They have not
get the-
attended to it, your
get
lordship.
that representation decided. that's all.
Lordship. Lord. Page 68, your lordship, is our representation. Your lord. Ultimately, your lordship, when state take a decision, it should be reasonable, your lordship.
Reasonable.
But that aspect, your lordships can always consider. your
Every decision of the state government is not open for judicial review.
That's
and
there,
purely
your
in
lordship.
these administrative matters.
That is there, your lordship. But unless your lordship, once you laid down a certain procedure, then your lordship, probably your lordship, that is why your lordship, to make it transparent and reasonable, that SOP has come.
In this PIL petition, the petitioners have prayed for a direction. Has prayed that the notification dated 19/10/2024 issued by the additional chief secretary Panchayat and Rural Development Department, whereby the village of Kalia, Naskara, under the Naskara Gram Panchayat, has been notified as the headquarter of Naskara Jamdar Hat Development Block. Full stop. The petitioners have claimed that the Kirakuti is the most appropriate place for the headquarter of Naskara Jamdar Hat Development Block instead of Borkalia Naskara. Full stop. It is also contended on behalf of the it is also it is the case of the petitioners that while fixing the above referred headquarter, the government has not strictly followed the standard operating procedure for development block reorganization. Full stop. Having heard the learned counsel for the petitioner and after going through the material available on record, we are of the view that fixing of headquarters of a development block is purely a administrative matter and comes within the domain of the executive. So, it is not the case of the appellant, petitioners that that while fixing the headquarter at while fixing the headquarter of Naskara Jamdar Development Block at village Borkalia Naskara, the government, the respondents have violated any statutory rules or has acted with malefice. Full stop. Learned counsel for the appellant has petitioners have frankly considered that the standing operating procedure for development block reorganization has no statutory force. Full stop. In view of the above, we are of the opinion that no mandamus can be issued as prayed for. No mandamus can be issued and the reliefs prayed for in the PIL petition cannot be granted to the petitioners in the facts and circumstances as noted above. Stop. It is claimed that the petitioners and other affected persons have already approached the additional chief secretary, government of Assam, for change of headquarter of Namsara, the Naskara, Naskara Jamda Development Block. And the same has not been decided till date to stop. If any such representation filed by the petitioners and other persons is pending till date, it is expected that the authority concerned shall dispose of the same expeditiously. With these observations, this PL petition. 18 representation dated 18/10/2024.
Lordship may fix some time period, your lordship, expeditious.
Please. We have granted this liberty only, otherwise there is nothing in this case.
I knew it, your lordship, defense.
Yes.
Obliged.
At least my friend has got something to tell his plans.
Item for-
Ultimately, it is, he has some material instructions, so that has to.
He is just fully justified.
Item 14 and 15.
With your worships. My lord, I think 14 and 15 are identical matters.
Yes,
May please your worships. My lord, this matter relates to an NIT for allotment of trucks for transportation of LPG cylinders. Now the respondent repetitioner appealed this court against my lord rejection of the tender on the ground that my lord, it did not fulfill the pre-qualification criteria. The honorable single judge has held that my lord, it fulfills the pre-qualification criteria. Against that we have come, my lord. Now, if your lordship kindly comes to the interim judgment of the honorable single judge, it starts at page 196.
yeah, para.
My lord, the finding the honorable single judge has given is, my lord,
Para,
at page,
para.
paragraph 7.
7. Yeah.
At page 197.
Yeah.
A perusal of serial number 1 of the above chart shows that the for owned attached trunks, the bidder would have to submit self-attested copies of the registration book or the smart card. If the same was not possible, the bidder was to submit an invoice accompanied with temporary authorization of registration certificate for a new truck. A third alternative has been enumerated, wherein it has been stated that the temporary authorization of the registration certificate for new trucks should be uploaded. It is clear from the chart shown above that the each of the truck owners would have to have documents as per the 3 alternatives mentioned therein. The third category of documents required for a bidder clearly provides that only a temporary authorization of registration certificate for a new truck can also be considered even in the absence of an invoice.
Yeah.
My lord, we have approached against this finding, my lord.
Why?
My lord, the chart
although my lord, it has been quoted at page 197, the original, which is a part of the my lord NIT, your lordship will find at page 89, your lordship will find,
93.
my lord, page 93. May I read that, my lord? Because, my lord, the honorable single judge has said, my lord, there are three alternatives.
You are right. He is right.
Your lordship will kindly read it, my lord.
Read.
Truck ownership, owned and attached truck, PQC document to be uploaded. For owned attached trucks, self-attested copy of form number 2323A, that is RC book and smart card, or invoice accompanied with temporary registration certificates, temporary authorization of registration certificates for new trucks.
Slash.
The slash is there, my lord. So, my lord, that slash, my lord, in my humble understanding, it means that, my lord, it has to be either temporary registration certificate or temporary authorization
That's right.
of registration certificate. If that be so, my lord, they have not, my lord, filed the invoice accompanied with
There is
this.
no need of that. Temporary authorization of registration certificate for new trucks. Temporary authorization is very much there.
Yes, my lord. Temporary authorization, my lord. If I read it again, my lord, for own address trucks, self-attested copy of form number so and so, that is, my lord.
Invoice accompanied with temporary registration certificate. It ends here. Temporary authorization of registration certificate for new trucks. It's altogether different.
Invoice accompanied with, my lord, temporary registration certificates. That invoice was missing, my
So
lord.
you mean to say that we should read it, invoice accompanied with temporary authorization of registration
Yes, my
certificate
lord.
for new trucks?
Yes, my lord. That is what, my lord, we understand, my lord. And in fact, that has been clarified by the, my lord, Transport Department also. We have filed an additional affidavit, my lord,
Yeah.
asking for their clarification. If your lordship kindly takes our additional affidavit, my lord.
So they have submitted the temporary authorization of registration certificate. That you are admitting.
That we are admitting, my lord, minus the invoice, my lord. If your lordship kindly sees the, my lord, the response of the Transport Department, because, my lord, this is how we understood and interpreted it.
What transport
The
department?
additional affidavit, my lord, we have filed. It starts at page, my lord, 30, page 100, my lord.
Yeah.
104, that is the, my lord, letter issued by the IOCL to the, my lord, DTO. Asking for confirmation regarding whether vehicle particulars disclaimer issued downloaded can be considered as substitute for valid vehicle documents. During our recent tendering process for induction of trucks for transportation of packed LPG cylinders, few of the bidders have submitted the following documents along with their bids, which were either endorsed by the respective RTOs or downloaded copies. Number one, vehicle particulars, disclaimers. Our tender conditions for acceptance of trucks was based on the following set of documents, which is considered as valid vehicular documents for evaluation purposes: RC form, then smart card, temporary registration certificate, temporary authorization of registration certificate. Few above, we'd like to request to the following to kindly confirm whether the vehicle.
Raise certain queries and they have replied it in.
The reply, my lord, that they have given is at, my lord, page 106. This is reference to a letter number such and such. It is to confirm that the vehicle particulars disclaimers cannot be considered as substitute of the valid vehicular documents as mentioned in 1 to 4 below, as per applicable rules and regulations. RC form, smart card, temporary registration certificate, and temporary authorization of registration certificate.
Although you have taken a plea, that the earlier particulars will not be also applicable to this. Right? But you yourself had carried out an examination and come to a conclusion that the vehicle had the RC license. You were utilizing the vehicle. And the disclaimer that you have now sent to the transport department for that was what he had provided is not particular. And also with the other documents you had it before you. So what was the handicap to come to a conclusion that yes, this vehicle satisfies the requirement? Because the age of the vehicles was clear. 21 days and 46 days on the vehicle. So in spite of this situation, why was it rejected? These are for your satisfaction you have taken.
Yes,
These vehicles are with you only. Both the vehicles are with you.
these are new vehicles, my lord.
They are operating. That gate tender, gate notice.
Gate notice.
Yes, gate notice. No, gate notices, my lord, we do not scrutinize, my lord, in that manner.
It's page 69.
My lord,
Yes. RC book available, yes. Carrying capacity, yes. So and so. Endorsement is yes. For the same vehicle.
yes, that is right, my lord.
That is right, then what remains?
And what you send the transport department, not particular. Yes. Respondent number 1.
No, we had asked the, my lord, generally.
General.
We have asked generally, my
So
lord.
you got a general.
Yes. My lord, we have to go on, my lord, abide by the guidelines that
The
have been
guidelines are very clear. And the learned singer rightly observed that there are 3 contingencies, one of them is met by.
The question is, my lord, whether, my lord, without the invoice that can be accepted or not, my lord, that is the only issue, my lord.
We don't find any.
I don't want to repeat, my lord.
That's better. My lord, can I just join in, my lord? That's why, my lord, a corporation must have a litigation policy. It's a very important point. A government, a corporation, they can be litigant. I'm sure, my lord, this is an action which does not, emanate from the litigation policy of the corporation. It's an aspect, my lord. What my brother is saying that it is beneficial for the respondents also. Again, this writ appeal is filed by the appellant agrees with the order dated 26/4/2024. Same, the separate.
Only, my lord, vehicles are different.
Vehicle numbers are different.
Only vehicle numbers are different, my lord. The finding is same.
These 2 writ appeals are preferred on behalf of the appellants being agreed with the order dated 26/4/2024 passed in writ petition number 1482/2024 and D. Passed by the separate order passed by the learned single judge on 26/4/2024 in writ petition number 1581 oblique 2024 and 1582 oblique 2024. Full stop. The said writ petitions were, the above referred writ petitions were filed by the private respondent number. Private respondent number one.
One.
Private respondent, only sole respondent is there, right?
Sole respect.
Sole respondent. By the sole respondents. Being agreed with the action of the appellants of the action of the appellants of rejecting their bids filed in response to the NIT dated 24/11/2023 for providing trucks for the purpose of transportation of
LPG cylinders.
petroleum.
LPG cylinders.
Good stop. The learned single judge, after taking into consideration the pre-qualification criteria for bidders mentioning in the NIT document, has come to the conclusion that a bidder would have to submit attested copies of registration book or smart card, or to submit invoice accompanied with temporary authorization of registration certificate for a new truck, or a temporary authorization of registration certificate for new truck. Full stop. The learned single judge has recorded a finding that the bidders have submitted the third category of documents, that is temporary authorization of registration certificate for new truck. But the respondents, but the appellants have illegally not considered the said documents on the ground that it has not been accompanied by invoice. This was the reason for that, accompanied by invoice. Invoice, full stop. Having heard the learned counsel of the parties and after taking into consideration the pre-qualification criteria for bidders, we are of the view that the learned single judge is rightly opined that every bidder was supposed to submit, was supposed to upload the documents regarding the offered drugs. In either of the three, in either of the three forms, in either of the three forms, as specified in three qualification criteria, and the respondents have submitted the third category of documents That is a temporary authorization of registration certificate for new trucks. Stop. In view of the above, we don't find any illegality in the finding of the learned single judge that the appellants have illegally declared illegally rejected the bid of the respondents. In view of the above discussion, we don't find any merit in this appeal. The same is.
Can I pray for a small observation, my lord? The learned single judge has not given any time frame. The judgment was rendered in April. Till date, my lord, they have not done anything. So they will proceed, my lord, forthwith.
My lord, we are on appeal against that order, my lord.
Appeal has been filed now.
The same are dismissed. However, it is expected that the appellant shall carry out the directions given by the learned single judge. For consideration of the case of the respondent for allotment of transportation of main LPG cylinder in terms of NIT dated 24/11/2023 expeditiously, preferably within a period of 1 month from the date of production of certified copy.
Item 16.
Material. This matter is relating to my amalgamation of schools, lower school into the higher school, I know than the name of the school. The whole question come, I take your lordships to, but the office memorandum, just. Thereafter, I'll take your lordship to page 39 and 40. This is the office memorandum dated 3rd August 21,
39,
page 39, annex 2.
yes,
Your lordship bottom, 7.
7.
After careful consideration of all aspects and to derive optimal service for employees and other location support to the school, it has been decided that a school situated in the same campus or any nearby area shall be amalgamated, marked, and all such schools shall be brought into one single administrative and academic unit under Shiksha Katra scheme. Following criteria shall be considered for such amalgamation marking. Now, we are concerned 1 and 3, my lord. 1. All the schools situated in the same campus shall be marked with the higher level school. If there is higher secondary school, a high school, and ME school and LP school situated in the same campus, then the high ME and LP school shall be amalgamated with the higher secondary school. Likewise, we fall on this model. Likewise, if the highest level school is high school, we have high school, then all the other schools subordinate to high school shall be amalgamated with the high school. The SMC, MDC of higher school, school or high school, so and so, as the case may be, shall continue, and SMC of all the other schools shall stand withdrawn. However, SMC shall be reconstituted with the inclusion of 2 representatives from guardian and so and so. Now can come the 3 mile, subclause Roman 3 mile. The name of the highest level school in which all other schools are amalgamated shall stand. The highest level school here shall be termed as base school. So in our case, my lord,
Yeah.
yes.
Yes.
Now you will kindly see page 49, my.
Yes.
Oh, sorry, 47. 47, sorry, 47.
Yes.
Yes. Order dated 29/3/22. In terms of that notification, my lord, in pursuance of the government office memorandum dated so and subsequently as per approval of the secondary education department, government of so and so, please to issue the order of amalgamation the following school. One school, that is ME High, so and so, the details. The name of the amalgamated school, my lord, Krishnanagar Anigram MB School. And it is amalgamated to Ahmadiyya High School.
And?
So, my lord, as per office memorandum 29, it was done. Thereafter, my lord, subsequently it was cancelled without hearing next page for it. And it remained by in the name of the ME school, MB school. That is, in consideration of this office RD, so and so director, secretary hereby pleased to issue an amalgamation order for the following school in so and so. The details after amalgamation, number 2, my lord. After amalgamation, mark the name of the school shall be so and so high school. Now you'll also kindly see, madam, the order of line is single judge.
If they've done it in violation of this, whatever the amalgamation policy, then you may approach the government for that
No, madam,
rectification.
just, madam, you'll also kindly come to the single line, single judge, madam. Just, I am from that, madam, page 18, paragraph 9, madam.
But they said they have no locus.
Locust and madam.
It may
No
be-
matter our case of that, we are the members of the managing committee.
Whatever it may be.
On the face of it, madam. We have stated, madam, you lost kindly paragraph 20, page 31. Page 31. We have categorically stated we are the members of the managing committee.
No doubt.
So on that basis, it cannot be, madam. I am only on that.
Para number 9, the learned single judge observed this, but ultimately the learned single judge has not non-suited you only on this ground that since you have no locus standi, I am not going to interfere. It has simply said, "Okay, approach the government for that."
No, madam, it was pointed out, it was not controverted without filing an affidavit also, madam. It was not controverted also, madam.
Not controverted, we understand.
Yes. Now, appeal, madam, when we have filed a representative to the government, nothing has been done,
Representation will not do, sir. You file appeal
madam.
as provided under clause 19.
Now, appeal when comes, madam, if there is a pay, your lordship, clause, that is office memorandum.
Yeah,
Yes, your lordship,
clause 19.
yes, office memorandum, madam.
Director concerned will necessarily order of amalgam for any dispute arising out of the order. The aggrieved institution public may appeal before the government in the secondary or elementary education department as the case may be.
So that is for amalgamation. Appeal lies with regard to if there is a dispute regarding amalgamation.
Any dispute.
My
regarding
case is, my lord, you
amalgamation
have
of
already,
shape,
no, my lord, kindly, my lord.
That includes every dispute, sir.
My lord, amalgamation, I have nothing to say. It was not at all under this in dispute, my lord. My question, my lord, you have already amalgamated. You have given a name. After 2-3 months, what is the reason which compelled it to?
Mr. Chaudhary, please.
My- my-
Director concerned will issue necessary order for amalgamation. Yes, it has issued the order wherein it has pointed out that the school will be called as in so and so name. Any dispute arising out of the order.
Director
It
concerned.
says of order, not only amalgamation order. So if you are aggrieved by this order that why they have mentioned the name of so and so school instead of Ahmadiyya school as a base school, challenge it.
My lord, I have not challenged that one. Arising out amalgamated, I am not challenging that one.
Sir, any
I am on that. You have
order-
cancelled the amalgamation order, my
Sir, it order speaks of everything.
my lord.
Speaks of
In my humble understanding, my lord,
We'll
any
clarify
dispute arising out of the order of amalgamation.
We'll clarify it, that even though this clause 19 is not so specific, we'll clarify it that this dispute shall also be decided by this day.
My lord, the managing committee of both the committees, my lord, both the schools, but all the my lord, that there is also some that scope have been given and they have held a meeting also, my lord. That could have been also done. Let the managing committee take a decision, my lord, both the managing committee. If they think, my lord, now where from you have come and you have cancelled the order.
let the state government define any person aggrieved by this, what is fixing of base.
My lord, in my humble subject of your lordship, say I have nothing to say, my lord. My only question, my lord, this 19 is not applicable in my case, my lord. 19 comes, my lord, if there is a dispute arising out of the amalgamation order, my lord. I am not on that, my lord. My case is, my lord, you have already amalgamated. The agreed management was not disputing the fact, madam. They are also not disputing.
Fine.
Where from authority come from this floor and they have passed the order? Whose basis? What is the reason behind this, madam? Nobody has approached, madam. Neither that group nor this group, madam.
It's also,
Madam. Madam, if there is money, anything is there, let the joint committee also, they also may decide, madam. Instead of going to the government, let the local, they decide it, madam. No problem, madam.
this is the appeal is filed by the appellant being agreed with the order dated 9/9/2024 passed by the single judge in writ petition number 5219/2022, whereby the learned single judge has disposed of the writ petition filed on behalf of the petitioners, appellants, while granting them liberty to approach the appellate authority for redressal of their grievances. Full stop. The brief facts of the case are that under the Shiksha Kshetra scheme, which provide for amalgamation and merger of different provincialized lower primary, upper primary, high and higher secondary schools with the base school of the state. The government has issued a notification dated, the secondary education department has issued a notification dated 18/2/2022. Amalgamating the Krishna Nagar Rangiram MV School of District Karimganj with the base school Ahmadiyya High School of District Karimganj. Full stop. Later, by another order, by the DSC means
Director, secondary.
Director Secondary Education dated 1/6/2022. The earlier order 29/3/2022 was cancelled and a fresh order for amalgamation of Krishna Nagar Rangiram MV School of District Karimganj with the base school Ahmadiyya High School District Karimganj was passed, wherein it is provided that after amalgamation / merger, the name of the school shall be Krishna Nagar Rangiram High School. Stop. The petitioners, the appellants have claimed before the writ court that the said amalgamation wide order dated 1/6/2022 declaring the Krishna Nagar Rangiram Ranigram High School as base school is in violation of Office Memorandum dated 3/8/2024 with regard to Shiksha Kshetra scheme for amalgamation and merger of different schools. It is contended that as a matter of fact, the Ahmadiyya High School was the highest.
Yes,
Ahmadiyya High School was the highest level school
in the campus.
in the campus, and the Rangiram MBA school is
It is nearby, but within 10 meters away from the main school. Rule says either in the campus or nearby.
is not the school in comparison to the level of the Ahmadiyya High School, and therefore the said and therefore the action of the respondents of declaring the Rangiram MB school as base school is illegal. Stop. The learned single judge after reading, after taking into consideration the arguments advanced on behalf of the parties, have recorded a finding that the appellants have no locus to challenge the has no locus standi to challenge the order dated 1/6/2022, renaming the amalgamated Krishna Nagar Rangiram MB school as base school, because neither their children are studying in the said school nor they are not members of the school managing committee of the Ahmadiyya High School. Full stop. Learned High School. However, the learned single judge has taken into consideration the Shiksha Kshetra scheme and has observed that against the decision of the state government, against the decision of the Director Secondary Education, renaming the amalgamated Krishna Nagar Rangiram MB school as base school, the appellants can file an appeal to the state government or to the education department as per the clause 19 of the Shiksha Kshetra scheme. Full stop. Learned counsel for the appellant has submitted that the learned single judge has illegally questioned the locus standi of the appellants while observing that neither their children are studying in the Ahmadiyya High School nor they are members of the school managing committee of that school. Learned counsel has submitted that as a matter of fact, in para number 8 of the writ petition, the appellants have specifically pleaded that they are the members of the school management committee of Ahmadiyya High School, and the said assertion of the appellants have not been controverted by the respondents, by the state and other respondents, and in such circumstances, the said the said finding of the learned single judge is liable to be set aside. Full stop. Learned counsel for the appellant has further submitted that under clause 19, the appeal can be preferred against an order of the, against an order of amalgamation and not of fixing of the base school, and therefore the learned
No, change.
fixing of the name of the school,
Change.
amalgamated school, and therefore the learned single judge was also not right in relegating the appellants to avail the alternate remedy of filing an appeal under clause 19 of the Shiksha Kshetra scheme, which stop. Learned counsel for the appellant has therefore submitted that the impugned order passed by the learned single judge is liable to be set aside, and the relief prayed for in the writ petition filed on behalf of the appellants may kindly be granted. Full stop. Having heard the learned counsel for the appellant, and after going through the material available on record, we are of the view that the learned single judge has not taken into consideration the fact that the appellants have specifically pleaded in their writ petition that they are the members of the school management committee of the Ahmadiyya High School, and the said fact has not been controverted by the respondents in the writ petition. Full stop. In such circumstances, the said finding of the learned single judge cannot be sustained. However, however, we are of the view that the learned single judge has not committed any illegality in relegating the appellants to approach the appellate authority against the renaming of the amalgamated school. Full stop. The contention of the learned counsel for the appellant that the action of renaming of the amalgamated school cannot be challenged by filing an appeal under clause 19 of the Shiksha Kshetra scheme is not tenable, because clause 19 specifically provides that any dispute arising out of the order, which means the order whereby the different schools have been amalgamated, or name of the amalgamated school is mentioned, can very well be challenged by way of filing an appeal before the appellate authority. Full stop. In view of the above discussion, we don't find any case for interference. However, it would be open for the appellants to prefer an appeal as provided under clause 19 of the Shiksha Kshetra scheme within a period of
2 weeks now.
within a period of 2 weeks, challenging the impugned order passed by Director of Secondary Education dated
1/6 to the 20th, page 49.
1/6/2022. Full stop. If any such appeal is before the appellate authority, full stop. If any such appeal is preferred within the above referred time, it is the appellate authority shall consider and decide the same expeditiously within a period of 6 weeks thereafter, after providing opportunity of hearing to all the affected parties. With these observations, this writ appeal is disposed of.
Publish. Time দিছেন কতদিনের মধ্যে?
60 days.
Item 17.
May I please, Your Lordship? I prefer this appeal, Your Lordship, against the
Yes.
Yes. I have challenged the singular order, your lordship.
Have we joined at the new place?
No, I was on leave till 31st October, your lordship.
Okay.
Today is 4th, your lordship. Regarding reluctant to pass the interim order. So the basic question is that whether I primarily as a case for grant of stay order, your lordship. I have challenged my transfer order, particularly in violation that the transfer order was passed by not by the competent authority, in violation of clause 4.3 of the transfer policy. Next.
This was the only ground.
No. There are several other grounds also. Then, your lordship, even if any transfer has to be taken place, the senior most person has to be transferred. There are many persons, clause 4.1. That is a violation. Next, your lordship, clause 10, regarding exemption from transfer. On the ground of mega academic session of the children, illness of the spouse. Here, my daughter is in the mid session of, she is undergoing BSc code, your lordship. My
BSc?
wife, yes,
BSc.
no, my
Mature
wife,
enough. She is mature enough.
yeah,
What is the mid session?
yeah, I am coming to that, your lordship. That apart, my wife is a diabetic and she undergone a fracture in the leg.
Nowadays, diabetes, you can't.
Not only that, no,
Very
not only that, your lordship, she has undergone a fracture of the leg, your lordship. Now, my widow mother is there. She is 85 years old. I am the only male person.
We understand that, but every household is having, every person is having such type of problem.
So clause
Old is his parents.
4.3 is there, your lordship. 4.1 is there. That apart, your lordship, clause 9.10, which provides for disposal of my representative within 20 days, that they have rejected during the
They
pendency
have
of the writ.
rejected.
During the pendency of the writ petition.
Fine. Ultimately, you
And
argue all these points before the learned single judge. Why are you inviting any
Your
this,
lordship, your lordship, by
finding
not,
from division bench?
your lordship, by not granting the interim order, my writ petition become infructuous, your lordship.
Why infructuous?
What will be there, your lordship?
They will be there, the learned single judge would consider it, whether this
So,
transfer was an-
your lordship, may I kindly take your lordship, the policy, your lordship. Kindly, for a moment, your lordship, page 50,
50,
page 50.
50.
50. May I read, your lordship? First paragraph. The transfer policy of AAI issued by letter dated so and so and subsequent to various amendments, the following transfer guideline shall govern the transfer of non-executive and executive.
So it has statutory force.
The fourth.
Huh?
So
This transfer policy is having some statutory force or not?
yes,
Yes.
yes.
Where is that?
No state of, no state of, but it has been, shall is there, but it has to be followed, your lordship.
Has to be.
Now, for a moment, next page, your lordship, page 51, clause 4.3.
Yeah.
Transfer of Group C staff, I am Group C staff, under the administrative control of RHQ, regional headquarters, shall be done by RED, Regional Executive Director. Here in the respondent number 3.
It is these transfer policies are having no statutory force. If you are arguing on this, we can very well observe this, that this transfer policy has no statutory force and therefore you can't harp upon it. Yes, it is for the indicative, the policy, while transferring, they should have to take into consideration.
I'm
If
just
there's no
placing-
statutory force, then it is not liable to be mandatorily followed.
Yes.
That is the position of the law.
Hmm.
If you want this finding, we'll give you right now. Then you'll lose everything before the learned single judge also.
I'm just pointing out what of the violation, your lordship. Then your lordship clause 4.1,
Yes.
except in cases where operational administrative reason warrant, transfer shall normally be avoided. Transfer when made shall be in accordance with seniority in stay at the station of the region. Now, your lordship, there are several persons who is senior to me. I have stated in page 40, sorry, your lordship, page 43 of the memo of appeal. Page 43, para 10 of the petition, that the petitioner beg to submit
Yes.
submits that as per clause 3.1 general condition for transfer and clause 4.1 provides for transfer shall be made according to seniority in stay at this station in the region. For example, one of his colleague, Srimati Shuklavedya, is working in the same station since 1990.
Which post?
Same post, senior superintendent. Next, your lordship, in the impugned transfer order itself, there are another two persons, Miss Jayanti Das and Madhuli Kuli. They are working at Guwahati since 2008.
You are
2008,
working since?
as senior citizen in 2019.
You are working here in Guwahati since?
Now I'm working at Silchar as senior superintendent since 2019.
Uh,
Now,
Enough,
I leave up to your lordship. This is the case, your lordship. These are the premises ground. These are the premises ground which I have raised
The prima facie, you
before the
satisfy
learned
single
single.
judge, get the writ petition decided.
Now, whether this power,
Otherwise-
whether the power of the competent authority can be delegated to your lordship.
That learned single judge is prima facie
Now,
observed
what-
that this
what
power
the-
is there, that's why only.
No, what the learner
Stay the transfer order.
at para 9 of the single judge judgment, your page 27.
Read.
Today, when the matter is called, Mr. Dubey has placed the certain records as regard HRM annual transfer 2024, from where it appears that the necessary approval of the concerned authority, RED, NER has been obtained before passing the order. Now, whether these power can be delegated or approved, even they do not admit, your lordship, if there is approval, from where there is no discussion about
What discussion?
approval order, by which order it has been granted. The basically is that it cannot be delegated power.
Okay, please try to understand. If these are the only grounds that you are saying that it is in violation of the statutory policy, the transfer policy, then we can very well observe this, that transfer policy has no statutory force and therefore.
These are the
Nothing
only
can
few
be-
grounds, your lordship.
Then there would be nothing left with the learned single judge to decide.
Any observation? Yeah. I leave up to your lordship, whatever objection, your lord. Because these are the, not only few of the ground which I have taken, your lordship.
There is a saying, हिंदी में एक कहावत है कि वो चौबे जी गए छब्बे जी बनने और दुबे जी बन के लौटे, वो वाला हो जाएगा। क्योंकि अभी हम यहाँ पे इसी बात पे ही खारिज करते हैं, then what you will get.
Dubai is very much here.
Withdraw it, pursue the writ petition. It's better for your client. After attempting to argue the matter for quite some time, and wanted for the appellant on instructions has submitted that he does not want to press this writ appeal at this date.
Right.
Does not press.
Item 18.
From school, have come to municipality.
Yeah.
Yeah, madam, my only theory also see, madam, the imping order all of the single bench, madam, paragraph. What page 41, madam?
41.
Yeah. We see my first page 36, madam, paragraph 3, madam.
Yes.
Yes. The issue involved in the instant batch of revision is, your lordship got it, ma'am. Paragraph 3, page 36,
Paragraph 3, yeah.
madam. The issue involved in the instant revision is a legal issue as to whether the considerations or objections in terms of section 3 of the Act 22 have been done in accordance with the provision of the said Act. The grievance of the petitioner as have been submitted by the learned senior counsel appear on behalf of the petitioner is that the objections which are submitted by the petitioners have been perfunctorily disposed of without showing that there has been any consideration. In addition to that, the learned counsel appearing on behalf of the petitioner have also submitted that in terms of section 3(4) of the Act, it is only the state government who is to decide such objections and not by the deputy commissioner. And in the instant case, it would have seen from the enclosure to the affidavit of opposition, the communication dated 4/11/22 issued by the deputy commissioner that the consideration and the decision was made by the deputy commissioner and the state government did not further make any endeavor to make any further consideration. Now, then you will kindly see page 41. Paragraph 11, in the instant case, the dispute revolves around subsection 4, section 3, which stipulates that the manner in which the objections are required to be considered. The ground on which the imping notification dates have been challenged have already been mentioned here. So the question which therefore arises is that whether the said ground merits or not. Now, if you lordship kindly come to paragraph 12, so yeah. This court, upon perusal of the materials on the record, as well as hearing the learned counsel, including the learned Advocate General of State of Assam, had sought for the records on the basis of which the consideration was made by the state government. In pursuance thereto, the records were produced and the relevant note sheets were also placed before this court. The copy of the note sheet which was produced is kept on record and marked as Annexure 10. Then you should come to this. So I'm just coming to later on this part, my lord. Now, first of all, my lord, first of Deputy Commissioner submitted a report. And you kindly say report, what is there in the report, my lord? Initially, my lord. Page. No, yeah, affidavit starts from 197 and your lordship will find ground will hold ground page 200. Your lord kindly page 22, madam. 222. Lordship, madam.
Yes.
Our case falls on serial number 3, madam, page Annexure 3222 page. It is the part of the affidavit filed with the Deputy Commissioner. Here your lordship will find the serial number 3.
Yeah.
Objection against the inclusion of Dudbatil, Silchar, so and so. Right side your lordship will find the petitioners present. Their contention is that the area is backward and agricultural land. Corporation tax will overburden the people. On scrutiny of facts, it appears that their objection is not tenable. And our objection was 79, my lord. Objection initially, my lord, this authority have asked that you hear the Gau Sabha, you hold the meeting of Gau Sabha, whether they are in favor of inclusion or in favor of the exclusion. That was done. then about 500 people, then 1,000 people filed a representation that it is that EMI. Now, you will also find a single judge, my learned, my additional legal general, oh, sorry. No. I'm beautiful. Objection কত পেয়েছি? এটা কোথায় দিয়েছি? Then my page 43, 16 and 17, madam.
Yeah.
And single judge has passed the order on the basis of this subsequent relation of the records, madam. Page 43, paragraph 16 and 17, your workings.
Yeah.
So that was, madam, that during the time of hearing, my lord, this was not at all mentioned in the affidavit filed by the Deputy Commissioner. That I have been asked to.
If the record, in the record, these proceedings are there.
That proceeding there, it was, we have not got the opportunity to see it, my lord. They have not reverted it, my lord. My learned friend has appeared, so we are not saying on that, my lord. That it was produced during the course of hearing, and on the perusal of this finding was there, but some hearing and some reasons were recorded, my lord. Some reasons were recorded. Our question is, my lord, this question, my humble submission is that, my lord, maybe it is subsequently might have been, my lord. Or your lord, kind is the affidavit they have filed on 4/11, 26/7/23, my affidavit which they have filed. In that affidavit, they did not mention about this, my lord, this part,
Yes,
about
Mr.
this finding.
Yeah, what is this?
I have to examine, lordship. What my learned friend is now indicating that we have manufactured.
No,
it subsequently.
I cannot say like this.
Now, as a afterthought, this is what is,
Maybe
is what
he may
is-
say because
No, at least I cannot blame that one.
just
the
Understand, my
affidavit was,
it creates a doubt even in our mind. Also.
so I'll definitely check it, but these kind of things are never done in the,
Maybe, but why this happened? You please clarify.
because the affidavit,
Along with your affidavit,
the record was produced by the state government from the department, and the affidavit was filed by the deputy commissioner.
Just a minute. This para number 17 say, for the purpose of instant bachelor, it may be relevant to incorporate the specific observation of the deputy commissioner Kachar in for objection, such as so and so is there. And this letter dated 4th of November 2022 is also from the office of the district deputy commissioner Kachar. The same authority.
The record was, because it was sent to the government.
You clarify this position, right?
No problem.
Why this discrepancy is there?
In my humble submission.
Because the record which was produced before the learned
Because during the
judge
course of hearing
from
of
the deputy commissioner, these observations are there or some that they have considered in detail the objections. Or here it says only that on scrutiny of the facts, it appears that their objection is not in. Nothing much discussion about.
this record was produced because during the course of hearing.
Uh, At two, Mr. Chaudhary. So Chaudhary,
My lord.
this, whatever the discrepancy we have noted, that has been clarified by the learned single judge in para 16 itself. Of the impugned order,
My lord. Paragraph 16.
yeah,
The court has also taken, this is the paragraph, ma'am.
Yeah.
The court has taken note of that pursuant to the communication dated 4/11/22 being submitted before the commissioner and secretary to the government of Assam. The state government, upon perusal of the claims and objection, as well as letter dated 4/11/22, requested the Commissioner Kachar to submit detailed specific observation against each of the so and so. Pursuant thereto, Deputy Commissioner Kachar had submitted communication dated 14/11/22, providing detailed observation against each of so and so. That is not mentioned in the affidavit filed by the Deputy Commissioner.
but here the learned single judge has taken into consideration this fact that on 4/11/2000.
When they have taken, my lord.
Whatever the reasons
that-
this deputy commissioner has mentioned,
My lord.
those are not sufficient and therefore they ask for more clarification.
No,
Then this 14/11/2022, which has been quoted by the learned single judge in the order, they have supplied the reasons.
but that to be, it is to be done by the state government, not by the Deputy Commissioner. My lord.
No. He
They
has
cannot
simply-
delegate it also, my lord.
He has, since he has not recommended for that or whatever he has, to include those two villages in the Silchar, he has given his justification. And then the state government has taken into consideration and decided the
So
same.
that is what I am to, my lord, whether they have taken into consideration or not.
This is what it
This is
reflected from
the,
this.
your lordship kindly say our objection also, we have also stated, my lord.
Yes,
We have also stated in our place, 179 paragraph, my lord, we have also,
yes,
that is their, our only case, this is the case, my lord.
yeah.
That determined, they have not ever taken into consideration on their own, my lord.
What are your objections?
Yes, 179, your lordship kindly, say. Page 179.
179.
Yes. Yes. That is, my lord, dated 21/10/22.
Yes,
Marked as proposal, ward number 1, your lordship, 2, middle, my lord, that again we'd like to inform you that. First, my lord, that we, the people of Amalgamation village area, submitted several petitions before the owner since the inception of notification of the proposal. We are found not to include and under the same which is marked as so and so, ward number 1. That again we'd like to inform you that why the people of so and so are not interested to include. Number 1, said villages are not included under the Silchar Development Authority and Silchar Municipal Board. Said villages are under rural and GP area. They are separated by 3 rivers like Barak, Madura, and Laksing. As per census, the population of the village are about 3,200. There are about 85% people belong to cultivation, agriculture. About 70% areas under agricultural land. Density of population of village 2 is about 4.57. Then there is no small scale food processing unit except 2 private small rice mills in the absence of 2 villages. The above 2 villages have to depend on E&D barn transportation goods from one place to another place, and there is no PWD road existing in the above villages. The above 2 villages are flood affected areas as the villages stand in the bank of river Soin. There are little poor shopkeepers. Then there is no market, no hospital, no high school, no higher secondary, no cattle market, no weekly market, no handloom industries.
these are the general.
So these are the things, matter what they, because they are villager, some schemes are actually meant for the village, Gau Panchayat level, mind. Once they're included, they will be deprived of all the benefits, mind.
Schemes for the urban areas also.
No,
They
that
are
Gapun area, matter in rural areas, some Gau Panchayat village, by the Panchayat system.
We are not sitting here as a appellate authority.
Madam.
It's the decision of the, whatever the administrative authorities. And these, whatever the reasons he has mentioned in 14/11/2022 letter, this appears to be justified. That the said area of Dudupati has already included in draft Silchar Development Authority Master Plan 2045. The population density in the area is also increasing. Construction of two number of bridges have been completed in this area. And
That is, we have disputed.
for two bridges, that's there.
That we have disputed, madam. But you should kindly have a look to 243Q subclause 2, my lord, of the
Yes.
Constitution of India, my.
Yes.
Not the Constitution. 243Q subclause 2, my.
Yes.
Yes. Your lordship, Constitution of Municipalities, my lord, that I am not on that, my lord. 2, my lord.
Yeah.
In this article, a transitional area, a smaller urban area or a larger urban area means such area as the governor may, having regard to the population of the area, the density of the population therein, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance or such other factors as may be fit, specified by public notification for the purposes of this part. In terms of this, now, if you also kindly come to section 3, my lord, of the Municipal Act, my lord. 2022, my lord. Yes, ma'am. Your lordship, and is section 3, my lord, Constitution of the Corporation. That is the language they have used, my lord, as per Constitution. The governor may, after making such inquiry as he may deem fit, my lord, that is as it is. Now you must kindly see number 2, the publication of declaration, my lord. Notification about the Constitution of the Corporation shall be published in the official gazette.
3.
My lord, section 3, 2, my lord, reading 1, 2, 3, 4, my lord. Section 3, my lord. 2022. I'm handing over, my lord. Asana.
It is quoted in the judgment also, no? The Constitution.
Judgment clause.
Judgment, the constitutional provision.
My lord. Declaration number 3. Peace. P1, the governor may, after making such inquiry as he may deem fit and having regard to the population, same thing, my lord. For Article 43Q, my lord, 2, it is mentioned. Then kindly come to my lord. The publication of declaration, number 2. A copy of the, then 4, your lord, consideration of objection, my lord. Any inhabitant of the city, town, or panchayat area in respect of which a notification has been published under subsection 2 of section 3 may, if he objects to anything contained in the notification, submit his objection in writing within 15 days of the publication of notification to the state government, through the deputy commissioner of the district, and the state government shall take such objection into consideration.
Fine.
So this is my case, madam. Objection they have given with some observation, madam. Now they have to do state government on their own, madam. They have to consider whether the observation they have made, that is in terms of section 3(1) as well as 243Q, madam.
Fine.
Whether that has been done, my lord, I'm not known that, madam. This is deputy commissioner, nothing to do, my lord. He is to send the report with the observation. Fine, he did it, my lord. Now, what you have done, what state government has done,
On 17/11/2022,
my lord.
they have taken into consideration and rejected those objections.
Simply by saying will do, my lord, from that year, it is as it is. Deputy commissioner sent the objection, page, your lordship, page 44. Page 44 of the 43, my lord, that the petitioner were present, that is how they have done anyway. These things have been given by the deputy commissioner. So they have taken into consideration, they must have their independent own decision, my lord. In my humble understanding, subject to your lordship, my lord. What are them? Paragraph 17, my lord. Paragraph 17 says, it may be relevant to incorporate the specific observations of the deputy commissioner in so far as the objection which touches the so and so, so and so. Where is their consideration, my lord? I'm only on that, my lord. The rest is up to your worship, my lord.
Paragraph 16, Lordship, it is very clearly clarified. That is why the records were called for. And record was called for at 12 o'clock. At 2 o'clock, we produced the records. So there is no case of manipulation at any.
No, that I am.
Paragraph 16, the court has also taken note of that pursuant to the communication dated 4th November 2022, being submitted before the Commissioner and Secretary to the Government of Assam, Housing and Urban Development, Urban Affairs Department, the state government, upon perusal of the claims and objections, as well as the letter dated 4/11/2022, requested the Deputy Commissioner to submit detailed specific observations against each of the 46 numbers of claims and objections. Pursuant thereto, the Deputy Commissioner Kachar had submitted the communication of 14, that is 10 days later, providing detailed observation against each of the 46 numbers of claims and objections. So there was application of mind, there was consideration of every aspect which was deemed appropriate by the government. And therefore, the Deputy Commissioner was also asked to give further details. And in our affidavit at page 198, paragraph 5. With regard to the statements made in paragraph 4 of the writ petition, the deponent begs to state that Dhupati Part 4, Dhupati Part 8, and Boru Dhupati grant constitutes the Dhupati GP. As such, only Dhupati Part 4, Dhupati Part 2, 7 part, which is densely populated, had been incorporated in ward number 1 of Silchar Municipal Corporation, and remaining part of both the revenue villages along with Dhupati Part 8 and Bor Dhupati grant have been excluded from the corporation area. Therefore, only a small part of Dhupati GP has been incorporated in the Silchar Municipal Corporation. So we have considered everything as per the constitutional mandate, the population, density, as well as the mode of livelihood, plus the communication. It is also not fact that only means of communication in the area is country boat. The area is well connected with Silchar by Metal Road via Madhura Mukh Road, which has been a part of the proposed municipal corporation. Apart from that, construction of bridge over River Barak at Annapurna Ghat have already been completed, which brought the area within 100 meters of Silchar town.
Yes.
So due application of mine with all reasonableness, Lordship, it was done.
This was filed by the session. This was filed by the Deputy Commissioner, not government.
Deputy Commissioner is an extension arm of the state government.
Certainly.
Yes.
Madam, my question. My question, madam, that was this evidence filed by the deputy on 20, my lord, 26/7/23. So he did not mention about that one. Moreover, my lord, what paragraph 17 says, my lord. And again, my lord, your lordship, troubles, my lord. Page 7, paragraph 17, page 43.
Fine.
For the purpose of the state petition, it may be relevant to incorporate the specific observations of the Deputy Commissioner Kachar in so far as the objections which touches on the state petition and the same are incorporated therein under so and so. So these observations made, the Deputy Commissioner has been incorporated. My question, what is the consideration of
Not
the
the
state
state
government?
government. Not the state government.
State government. This is my case, man. But section especially says by the three subsection 4, my lord.
That's all.
My-
Close for order.
Highly
Obliged
obliged.
to your worship.
With the consent of the parties finally heard.
My lord.
Lordship. In fact, in the records, we place the note sheets also, how it was dealt
Yes,
with.
that is mentioned in the judgment. Obliged, lordship.
Highly obliged.
Item 19.
No, item only may pay the matter pass over time being, your lordship.
In that case, it will be taken up day after tomorrow, Lordship.
It's not-
And if they want to file a response also, we have filed an affidavit.
Let's go.
That is up to them.
Yeah. Highly obliged.
Next week.
Next week.
13.
Lordship, not on 6th, your lordship. Lordship was to consider the interim prayer to the your lordship.
On that day,
On 6th, your lordship, otherwise.
6th.
13th, we have next week.
6th.
6th.
Wednesday.
Yeah, 6th.
Item 23.
Yes, Mr. Sharma. My lord, resolve those difficulties.
The portal has already been, my lord.
But he has raised concern that though it is already operational, but not working in what to say, to the satisfaction.
My lord, to that aspect, my lord, I have, my lord, communicated that aspect, my lord. That instruction I have not received. May I pay, my lord,
Last
some,
occasion, that was
some-
notice that
some more time, my lord, for that instruction, my lord.
So please, my lord, on 036, the respondent, they requested for 3 weeks' time. On 28/6, again, they requested that the matter will issue after summarization. On 6/9, they requested that after 2 weeks, they will giving a reply. The whole point is there are two parts aspect of the PIL. One is the online portal, the other is the mandatory disclosure under section 4. That mandatory disclosure under section 4 was a requirement which was supposed to be given in a compliance report to the Supreme Court. If the state can bring that compliance report on record, my lord, it will suffice.
My lord, to that aspect, my lord, I have sought for instruction, my lord. They have requested to accommodate for some more time.
this thing on 18th,
My,
18th,
18th.
18th November. Yes, Mr. Sharma. And counsel of the senior government advocate raise some more time to comply with the direction given by this court on 6/9/2024. On his request, list this matter on 18th.
Okay, deeply obliged, my lord.
Item 26.
Can it be taken up after some time, led by Mr. K. N. Chaudhary?
How much time?
5 minutes, he's there.
Take it on 18th 18th November.
Item 27.
May I please, Your Lord? Yes, my lord, in this appeal, the only issue is involved whether the completion and appointment given to the second son, the parents are deprived of the pensionary benefits on the ground that the parents
he was not depend upon the pension, my lord. Now, my lord, they have depend upon the circular, that is the way of 1997. And my lord, in that, but it is not clear. My lord, I am asking for the ADR pension. Initially, my brother was working in the grave. He died, my lord, on 10/5/96. Then, my lord, pension was granted in favor of the mother. But before getting the pension by mother, she died, father also died. Then the younger brother was appointed on compulsory ground in 1998. Now, they have initially denied the pension. When we have filed the suit, petition, they are agreeable to pay that till the appointment date, that is 98, I will get. Rest of the pension I will not.
That's reasonable.
But my lord, it is the accrued pension money I have to get as a next to the kin of the deceased.
Reasonable view. We don't find any case for interference. The learned single judge is rightly reasonably held that till you are appointed on the compassionate
But
ground.
my lord, with all respect, my lord, the money that I'm claiming, that is the arrear pension of my elder brother.
Which date to which date?
Pardon?
From which date to which date you are claiming?
I'm
arrears?
claiming from 10/5/96 to 1996, when my mother died.
Till 2003 when his.
18/10/2003.
And he was appointed in 1998.
So 98 in compassionate appointment, you were supposed to take care of your parents.
My lord, but the money that accrued from earlier,
Not at all.
that is the arrear amount, which
The
is my genuine
compassionate
amount, my lord.
appointment
How
is
can I
also
be
given
denied?
for that purpose only.
So that is my due amount to my mother, my lord, my parents.
To be due amount. After 98, you can't claim this.
After 98, my lord,
amount on
after
it.
98, my lord, with your respect, after 98, no question of pension, because I am getting salary.
After 98,
I am getting salary.
yes, and you were appointed on compassionate ground.
Whether, my lord, in that, when the pension was sanctioned, there was no such condition that because of your son's.
There is no question of that. There is a question of propriety that once you were appointed on compassionate ground in place of your brother, then you were supposed to take care of your parents.
That I am taking, but they are no more.
So
They
the
died.
learned single judge has only held lordship that he was appointed on 22/12/1998. From that day, his parents are dependent upon him.
Upon him. That's right.
But the money that has been accrued as an arrear.
But how can it be accrued when she was not? Once you were appointed on compassionate ground, you were supposed to take care of your parents. Up to 98, it's okay. But not after that. That's a reasonable view.
And in fact, lordship, my instruction is that the PPO has already been issued. PPO has already been issued for that.
For the period for which the learned single judge.
Yes, yes.
Fine. Yes. That's all. Yeah. This writ appeal is prepared on behalf of the appellant being agreed with the order dated 21/12/2023 passed by the learned single judge in writ petition number 5476 of 2030. The appellant has approached the writ court with a claim that the respondents be directed to pay the arrears of the family pension payable to his late parents in respect of the family pension payable from 10/5/1996 to 18/10/2003, as they were dependent on his late brother who expired while in service under the GREF, GREF, GREF. The brief facts of the case are that the elder brother of the appellant was working as sepoy Pioneer Corps, CGREF, care of 99 APO. He died in harness on 10/5/96, leaving behind his parents and the appellant. Stop. The late elder brother of the appellant was a bachelor at the relevant point of time. Full stop. It is not in dispute that the father of the petitioner expired on 21/8/2002 and the mother of the appellant and the mother of the appellant expired on 18/10/2003. During the said period in the year 1998, precisely on 22/12/1998, the appellant was provided compassionate appointment in lieu of death of his elder brother. Full stop. The learned single judge, after taking into consideration the office memorandum dated 27th of October 1997, issued by the Government of India, Ministry of Personnel, Public Grievances and Pensions Department of Pension and Pensioners Welfare, and the provisions of Family Pension 1964, 1964 has read with CCS pension in bracket pension rules 1981 has observed as under has held as under para 10 say is just para 10 to 11 and 12. Taking into consideration the above facts and circumstances of the case, particularly the fact that the appellant was provided compassionate appointment on 22/12/1998, his claim for release of arrears, his claim for payment of family pension from 10/5/1996 to 18/10/2003 has rightly not been accepted by the learned single judge. The learned single judge has rightly observed that the appellant is entitled for the family arrears of family pension payable to his parents from 10/5/1996 to 22/12/1998, when the appellant was provided compassionate appointment. In view of the above discussion, we don't find any merit in this report. The same is therefore dismissed.
Item 24.
Among list of the disciplinary. Again. Photo ko diyan. Tengo que copy दीजिए list of the मैं film दीजिए और फोटो फोटो ले दूँ.
Yes.
My lord, may I please a list of dates, my lord? List of dates. Now, my lord, the respondent number 5. He was, my lord, holding the post of headmaster when the, my lord, school was at the venture stage. In 2007, his
service as, my lord, the headmaster of the school was terminated. And the appellant before your lordship was, my lord, appointed as the headmaster of the school. That is in 2007. Then, my lord, in 2014, the school was provincialized. And, my lord, the service of the appellant before your lordship, my lord, his services were also provincialized as headmaster of the school. Now he has, my lord, attained the age of superannuation. He has retired on 1st of June 2024. Who? The appellant, my lord.
Appellant.
Yes.
Yeah.
my lord. And the private respondent number 5, my lord, he attained the age of superannuation on 6th of March 2023. Now, my lord, the only part, my lord, the appellant is aggrieved with is that, my lord, regarding his provincialization of service, because, my lord, his services were provincialized in 2014. The private respondent was, my lord, terminated from service in 2007. Appellant was, my lord, appointed as the headmaster in 2007 by the managing committee.
In place of that person.
Yes, my lord. And then, my lord, in 2014, my lord, the appellant service was provincialized. He served up to 2024, my lord, and he has retired. Now, the only part, my lord, he is concerned with regarding his provincialized service. Nothing has been clearly stated, my lord, in the judgment of the Honorable Single Judge about that, my lord.
Natural consequence, once if this termination of the respondent number 5 set aside, then your provincialization, all these consequential orders will also go aside.
In fact, if your lordship kindly sees the observation of the tribunal, my lord, and the Honorable Single Judge. Honorable Single Judge's judgment, your lordship will find at page 264 is the part, my lord, the effective part.
Yes.
Page 264.
Yeah.
Paragraph 50. Therefore, the termination of service of respondent number 5 by the resolution dated 22/8/2007 is not found sustainable on facts and in law. Thus, the order dated 28/2022 passed by the Learned Education Tribunal, Morigaon, in education case number 7, to the effect that the resolution number 3 is illegal and was set aside, which is impeded this writ petition, is not found to suffer from any legal infirmity or perversity whatsoever. The other directions are consequence and relief to the main relief of setting aside the resolution dated 22/8/2007. Now, accordingly, this court is inclined to pass the following orders. In view of the discussion above, the writ petition fails and the same is dismissed. The interim order passed earlier and the stands vacated. The judgment and order shall not come in the way for the petitioner number 2 to draw up a fresh disciplinary proceeding against the respondent number 5, if permissible, by following the due process of law, if so advised.
Once his termination was found to be bad, then natural consequence, your provincialization was subject to that only.
My lord, the provincialization is not automatic, my lord. There is a screening, my lord, committee.
Even though that was a screening committee, but your provincialization was due to termination of his services. Otherwise, he would have been considered.
My lord, if your lordship kindly comes to the, my lord, the finding of the tribunal.
Admit. Yes, you are for the private respond. Yes.
Yes, good.
Will admit this petition will hear. Having heard the learned counsel for the party, peer of the view, matter request come to the election, hence admit, no need to, since the counsel for the respondents are duly represented, no need to formal notice list this writ appeal for the hearing in the due course.
But regarding this.
Whether this order of the tribunal has been implemented.
No, nothing has happened.
Tribunal's order has been implemented or not?
No.
Before the learned single.
And thereafter, my lord, in the writ appeal also, my lord, there was some.
There is some interim order.
In the meantime, my lord, both the appellant and the.
Both have retired.
Now, my lord, my humble submission before the lordship, only regarding the date. Because my lord. Regarding date, my lord, that these things, additional courts, my lord, detected already he covered by 60 years. That's number 5.
He wants a short date, man.
Not.
He wants a short date.
Status quo it as exists today. In the meantime, status quo it as exists today shall be maintained till disposal of the writ appeal list for the hearing in due course in February 2025. Yes.
Obliged.
Item 28.
Well, here, Lordship, I pray for some more time. I am awaiting the instruction from the authority, my lord. The judgment of the learned single judge was passed in the month of March 2023. I am told that it has been complied with. They have already taken some steps. Now they have filed, my lord, after a long delay, my lord, they have prepared the writ appeal. But let me have the instruction, my lord, what action they have taken. The direction of the.
How much time will be?
Well, kindly give me 3 weeks time.
My lord, this is not a case of compliance, my lord. Basically, here is the case that disciplinary proceeding was initiated during my service and it was even concluded before my retirement, my lord. And the penalty was imposed that in the tune that all DCRJ has been withdrawn and the pension has been limited to 50%. That cannot be done because under Rule 7, my lord, appeal and discipline rule, my lord, there is no listed penalties, my lord. Therefore, learned single judge has, though set aside the penalty order, but exceeded its jurisdiction and converted the whole procedure under Rule 21 of the Assam Pension Service Rule, my lord.
Is that the only ground you are taking?
No, my lord. There are another grounds also, my lord. In merit, my lord, basically.
What are those another?
My lord.
What are those another grounds?
My lord, if your lordship look at the findings, my lord, first. My lord, so cause at page 48.
Yes.
Search number 1, my lord. It appears that while you were serving as executive engineer, PWRD, Morigo Rural Road Division, it is found that you have paid mobilization advances and equipment advances to contractor against bank guarantee of Udyogik Samabhay Bank Limited, Jorhat, which was found to be not a bank as per report of the RBI. This reveals that the payment of advances to the contractor was made without safeguarding the interest of government and in violation of PMGSY guidelines. So you are therefore charged for violating PMGSY guidelines and negligence to government entrusted duties. Charge number 2, my lord, it appears that while you were executive engineer, CPWRD, Morigaon Rural Road Division, it is found that although the contractor started the construction of road, still to be to Gagalmari, so-and-so, you have terminated the work in July 2010, as a result of which the advance amount could not be recovered, which led to a loss of government money. You are therefore charged lack of contract management, resulting loss of government money.
Yeah, Mr. Nath, what do you want?
But paragraph 22, page 106 of the judgment. This provides, my lord, while setting aside the impugned order, the honorable court has directed the respondent authorities to allow to continue with the departmental proceeding and bring the same to its logical.
From which stage?
But the order was set aside, the inquiry from the,
Which stage?
well, from the stage of inquiry, well, the inquiry officers,
Not there in the,
well,
which stage?
but that, well, in fact, the proceeding was initiated and the penalty was imposed at that point of time. The
Or
penalty
no
order goes,
proceedings?
Lordship.
From which stage?
But that instruction, my lord, I need, my lord, because after that order,
Clarify those.
yes, yes.
My lord, on the last occasion, interim was supposed to be considered, my lord. That may be the observation for the next.
13th of November.
My lord, much obliged, my lord.
Item 29.
Made to Jawad.
What happened in that?
My lord, that writ petition has been dismissed, my lord.
Dismissed?
Yes. That's a dismissed position. Yes. My lord, we are preferring an appeal. Writ petition is. I'm so sorry. I can move to me as writ petition has been decided against us.
Yes.
Yes. So what we are doing, my lord, we are filing a writ appeal.
Okay.
So my lord, may I pray this matter may come after 2 weeks. In the meantime, my lord, we will move that writ appeal.
The learned single.
Next. My lord, in this case, the learned single judge has taken a view which in our humble submission may not be correct, subject to what your lordships may say. The mother was tribal, my lord, and father was a non-tribal. Therefore, going by the Ramesh Bhai's case, my lord, ratio, she has to establish that her children were born and brought up in the tribal custom, which she could not. But learned single judge, my lord, has taking note of one paragraph from Ramesh Bhai, where an example was given, my lord, has held that since she is a daughter of a tribal, therefore she is deemed to be tribal. So that is a view, my lord, may not be correct. It's subject to what your lordships may say, my lord.
So have you filed an appeal against this judgment?
Yes, yes. My lord, any day, my lord, it will be filed, my lord. If I want to pull it. Okay. And state level scrutiny committee, my lord, came to the conclusion that she is not right. Against that, my lord, interference has been made by the learned single judge. Development. এটা আমার petitioner না criminal litigation 4204 4204 না 22 না we will not take. Presumption is against that. Milord. Ramesh Bhai. Kira. Milord, in Ramesh Bhai's case.
Let you file the
Yes,
appeal, we'll
yes.
consider it.
Yes,
We can consider the appellant has submitted that. Against the cancellation of the caste certificate. Against the cancellation of the ST certificate,
STP, Milord.
STP.
Scheduled tribe plain, not SC.
Scheduled tribe.
In Assam, my lord,
certificate
plains and hills are there.
issued to the daughter of the respondent number 6. The respondent has preferred an writ petition being 8024/2022, which came to be 8024/2022, which came to be decided wide judgment dated 3/10/2024, against which the petitioner has already, is going to
Yes,
prefer the writ appeal, and therefore this writ appeal may be listed, may be heard along with the said writ appeal. List on
my lord, any date after 10 days, my lord.
25th of November,
My lord.
25th of November.
Develop.
Let this appeal of 25th of November.
Passover matter 5.
My lordship. The lordship, the last occasion, my friend learned counsel took time to file a objection against my delay petition law.
Yeah,
Yes, we have an objection filed against my delay petition law.
Lordship, there is actually we have some difficulty, Lordship, regarding, we could not get a situation, Lordship, the situation we are facing. So here in the delay petition, it was not properly explained. So we need some time, not.
so what do you want?
So lordship, yeah, the learned single just lordship is a clear defined in para number 24, 5 and 6 lordship. So, termination order was set aside due to the non-est of the inquiry report lordship and directed to the respondent counsel to pay the area money from the date of the termination in the year of 2014 lordship. And that amount has not been disbursed by the concerned authority lordship.
That's another thing. But why you have challenged this order?
And lordship, my service has not been reinstated lordship.
Reinstate करने का once you were on temporary, your appointment was temporary up to a limited period.
Lordship is not
It
temporary.
was last extended for a month of how many days? 3 months, 6 months extension.
Lordship, what happened here in this case, lordship? So the allegation imposed by the concerned authorities are.
That's right. But the learned single judge has said, okay, since your this appointment was for a fixed term period, after that expiry of that period, the appointment was not extended, so you will be deemed to be treated in service up to that extended period. And for, up to that, you are entitled for salary.
Lordship, can you find Lordship page 31? So here Lordship, learned single just clearly find Lordship. Lordship, page number 31, Lordship.
Why you have challenged this order? Reinstatement, there is no question of your appointment was extended up to 13/9/2024. 2014, 13/9/2014. And before expiry of that period, your services were terminated in June 2014. The learned single judge found that this termination was not in accordance with law. Therefore, he set aside that termination
Yes, Lordship.
and ordered that you are and you'll get the salary for the period your services were extended. That's all. Up to September 2014, you will get the salary.
But one aspect is Lordship. So when the termination, my order was set aside, termination order was set aside by the concerned department Lordship. So code department has directed to whatever the salary ought to be disbursed. But my service has not been registered, Lordship.
Sir, services, there is no question of reinstatement of service. Your appointment was up to 13/9/2014. There was no extension thereafter. So what remains? What's wrong in that?
So Lordship, one
Page 83 was explained.
termination was it? Itu different is smart to appointment. So Lordship, I will do respect Lordship. So I'll take some instruction from my client Lordship to kindly fix and the short date Lordship regarding this Lordship temple.
We'll condone the delay and dispose it off. This appeal, making it clear that the petitioner is, this appellant is entitled for the due salary from 14/6/2000, from June 2016, 2014 to 13/9/2014. We'll clarify this. This statement you have not prayed for in the writ petition. You have not prayed for reinstatement in the petition. You have simply said, set aside the termination order and direct them to pay the due salary. This was the prayer in your writ petition.
And,
Yes.
And so far concern of the temporary service of the debt Lordship, on that I'll take some instruction from my client Lordship. So if possible Lordship.
Okay. When?
Short date, very short date Lordship.
Yeah. Then counsel for the matter comes upon for consideration of the application referred on behalf of the applicant. They pray to condone the delay of 212 days.
Yes, Lordship.
And filing the present connected appeal. Full stop. We peruse the application as well as the impugned order passed by the learned single judge against which the connected writ appeal is filed. So, learned counsel for the applicant raised some time to address the court on address the court on the ground of on the aspect of condoning the delay as well as the merits of the writ appeal list on 11th of November,
Yes, sir.
11th of
Mass office.
Supplementary list, item 35 for orders.
The application has not impeded the writ petitioner before the learned single judge as a party. But I am not impeded because your lordships asked that the advocates be asked to appear because the writ petitioner has not been made a party. There, some of them are appearing actually without instruction. I wish to bring that to the lordship's notice.
But
So they may have to amend their application. Be that as it may, my lords, because the application, I mean, that apart, and I would like to file a reply because well, it takes away a substantive right of appeal. I have today, my lords, invoked my right as
In fact, they are saying that since the matter regarding this, whatever the issue raised in the
Yes, sir.
PIN is akin to the issue raised by you in the SB petition, therefore the matter may be heard.
I follow what your lordship said, and when I read the
Because it
application.
may, there is a possibility that the division bench may pass some order and the single bench may pass some another order.
And if I may apprise your lordships, because what has happened is in this matter, in fact, considerable progress has been made in the, because before the single bench in terms of orders being passed. They were not agreed by those orders. And in fact, now and I may say, what have the orders unfolded?
Whatever the progress before the learned single judge will take into consideration.
No, I follow, my lord, because my point to problem today is, this is a PIL. I have invoked my personal right as a body recognized under 2015-16 judgment. My intra-court right of appeal goes away. In fact, Mr. Tiwari, who was here, unfortunately had to go to another court. He had a suggestion because I was being prejudiced. He says, a suggestion that which would be for your lordship's consideration that they could participate if the PIL was put on hold before the learned single judge, and then your lordships could also have the benefit of the appeal coming in, because today at the end.
PIL before the learned single.
No, they could participate as an intervener there, and the PIL could be put on hold. But something like that, because today at the end of the day, my statutory right.
Ultimately, this court right to appeal and whatever it may be, the division bench can also hear any matter in Article 2.
May I therefore, bring to your lordship notice what the rules say. The lordship just see that, because this application should have been preferred before the learned single judge. This application should have actually been.
If you are objecting this, that this should be heard and right to appeal and all this.
Your lordship may
public
look at,
importance
if your lordship may please say the High Court rules, my lord, if your lordship don't.
Yeah, give it up.
Because my lord, I lose a substantive right of appeal. And my lord, if I may say, why have they coming here now? They have not filed an appeal against any of the orders of the learned single judge.
No,
What?
they have simply said since the identical.
Yes, but why are they coming now? Because my lord, because what has this continuing mandamus issued by the learned single judge unraveled? Because your lordships have only issued notice in the PIL to the state of Assam, and my lord, that petition progressed. It has unraveled that the entire project that was being undertaken was dehorsed. The design, construction, and award of contract did not take into account the underground water springs. Only in June 2025 did they start a did they sanction a geo?
Still has not come, sir.
Please, Manoj. June 2024, that a geohydrological, because Manoj, today I will lose.
That was the submission made before us that
Manoj,
we are not
Manoj.
going to, we are not going to go ahead without their
Your lordship.
proper study. That's what here they have submitted.
And what kind of that is, I'm grateful to your lordship. What is the proper study? L Aston Tubro, who was awarded that contract, they are given the funds to engage a contractor. There's a fundamental conflict of interest.
The learned advocate general has made a statement before this court that they are not going to go ahead with the construction till this survey is completed.
Yes, Manoj, but who was doing the survey?
Sir, we don't understand what's the problem if you, this matter, the writ petition be heard by the division bench.
Manoj, my right of appeal gets taken away, Manoj.
Nothing. That's
Manoj, today I am asserting, your lordship may see the High Court rules, chapter 5, Manoj.
Yes. Yes.
Yes, may I read, Manoj?
It says that even the chief justice can't order for that.
The chief justice, Manoj, I think it will not be.
Okay, fine.
May I read, Manoj, if your lordship will?
Page.
Chapter 5, capital A, High Court rules.
Page 55.
55.
Page 50.
Your lordship, I think the book will be page 55.
55.
Of the book.
55.
Yes.
Rule 2, your lordship has?
Yeah.
Every such application shall be made and heard. Your lordship says the rules governing writ petition. Every such application will be made and heard before the learned single judge except by the chief justice, otherwise directs. Provided such applications falling within any or more
Where
of
the chief otherwise directs.
Otherwise, chief justice on the administrative side, because otherwise the language used is interchangeable now. It is not.
Such application shall be made and heard except where the chief otherwise directs.
Your lordships and on the as far as the roster is concerned, this matter as it goes before the now where did he need to file the application? Your lordship may just read the proviso. Provided that such application falling within any or more of the following categories shall be heard by division bench except where the chief justice otherwise directs: public interest litigation, habeas corpus application, any application which a single judge may refer to the chief justice for placing it before the division bench having regard to the importance or complexity of the case. They should have filed this application with a single judge. Why did they not file it there, my lord? Your lordship may say, I'm today at the end of the day, my lords, because the learned single judge issued notice to all the respondents, your lordships had not. Your lordship had only relied upon the state of Assam. Today, the state of Assam stands to be exposed to the extent.
You should be happy that even though we have not issued the notices, the division bench has not issued notices to all the respondents.
And this is a continuing one.
Notices to all the respondents, and if the petition comes here, we have to hear all those respondents also.
I follow, my lords. But the point today is my right of appeal goes, my lords. Then what happens?
Your
lordships may record my submission then, my lords.
Yes, we'll record.
Because my lord, my today
The application of the IA number 6 of 2024 referred in PIL number 12 of 2024. In the IA, it is prayed that the writ petition number 2700 of 2024, Navjyoti Sharma versus Union of India and others, be heard along with PIL number 12 of 2024. It is mentioned in the, it is stated in the application that in the writ petition number 2700/2024 is preferred by one Navjyoti Sarma, who is board theory of the Kamakhya temple with a prayer for directing the respondent authorities to declare Ma Kamakhya temple and all the temples of the Nilachal hill as protected monuments under the Ancient Monument and Archaeological Sites and Remains Act 1958 and the Assam Ancient Monuments and Record Act 1959, along with the prayer to conduct a detailed hydrological, ecological, and structural study before proceeding with any construction work of the Ma Kamakhya access corridor. Full stop. It is the corridor. It is further stated that the PIL, the PIL number 12/2024 has been filed with a prayer that any work related to Ma Kamakhya access corridor would not cause any damage or demolition or destruction of the age-old structure of the temple of Ma Kamakhya and all the Dasa Maha Vidyas, which are in the shape of natural water springs and cave, along with the prayer to not proceed with the work of the proposed Ma Kamakhya access corridor without taking prior approval and clearance of Department of Archaeological under the Ancient Monument Archaeological Sites and Remains Act 1958, amended amended in 2010, read with bracket close, read with the Assam as Ancient Monument and Records Act 1959. In the PIL, the petitioners have also raised the issue as to whether any hydrological study has been conducted to protect the natural springs or not be also be clarified by the respondents. Full stop. It is contended in the application that the subject matter of both the writ petition being writ petition number 2700/2024 and PIL number 12/2024 revolve around the same issue and therefore they may be heard together. Full stop. The application is opposed by the petitioner by the writ petitioner who has filed writ petition number 2700/2024. Learned counsel appearing for the petitioner in writ petition number 2700/2024, referring to rule chapter 5A of the Guwahati High Court rules, has argued that as per rule 2, chapter 5 capital A, every application under article 226, every application preferred under article 226 other than the writ of habeas corpus was required to be heard before the single judge. It is submitted that in view of the above provision, the writ petition filed by the petitioner is required to be heard by the learned single judge, it is submitted that if the writ petition filed by the writ petition number 2700/2024 is heard by the division bench, the writ petitioner of the writ petition will be deprived of remedy of filing an intra-court appeal in case any adverse order is passed against him in the writ petition. Stop. The net counsel appearing for the applicant has argued that since the controversy raised in both the writ petitions are since the subject matter of both the writ petitions, that is writ petition number 2700/2024 and PIL number 12/2024 is one and the same, it is appropriate to hear the matter by the division bench to avoid chances of passing conflicting orders by both the benches on the same subject matter. Full stop. Heard learned counsel for the parties. It is not in dispute that in both the writ petitions, that is writ petition number 2700/2024 and PIL number 2024, the petitioners have questioned the intentions of the state government of undertaking the work for improving the infrastructure at Kamakhya Mandir Temple Complex in state of in Guwahati under the Kamakhya, कौन सा है? Ma Kamakhya Access Corridor project. Full stop. More or less similar objections has been more or less similar submissions have been made in both the writ petitions, particularly initiating the projects without proper survey such as hydrological survey, etc. Full stop. It is the etc. Full stop. It is noticed that from time to time, the division bench has issued certain directions to the state government, to the state respondents as well as the respondents representing the Union of India and the council representing the Union of India. And the learned single judge has also passed several, has passed certain orders issuing certain directions to the respondents. Full stop. In such a situation, we deem it appropriate to club the writ petition number 2700/2024 with PIL number 12/2024 to stop. Otherwise also, though rule 2 of chapter 5A of the Guwahati High Court rules provides that every application filed under Article 226 of the Constitution, every application or every writ under Article 220 filed under Article 226 of the Constitution of India, other than the writ of habeas corpus, shall be heard before the learned single judge, except where the Chief Justice otherwise directs. Full stop. In such circumstances, we deem it appropriate by invoking the provisions of Rule 2 of Chapter 5A, we direct the registry to list this writ appeal number, the writ petition number 2700/2024, along with PIL number 12/2024 for further adjudicate.
Actually, file up for this. I'm telling the bill. But you will actually mention just one the attention.
Yes.
Actually, well, just, of course, your lordship has passed the order. I just want to point out the chief justice, because I read the rules yesterday, would refer the administrative on the administrative side.
Fine, we'll
And-
we'll delete that portion and we'll simply say the division bench
Yes.
can order. The division bench can order.
Yes, I know, but I've just wanted to bring this to your lordship's attention.
Yeah, okay, read the order. Last paragraph क्या है ना?
Doesn't matter. I just wanted to.
No, we'll correct this order. Yes, you are rightly pointed out. Yes. It can be done only on the administrative side.
We have filed an application before this division bench also. That is why that option is also open.
Last का जो है ना? नहीं, in such a situation. नहीं, so what है ना? Subject matter of the same. Yeah, that's all. Otherwise also you can this.
Grateful words.
Directly applies.
Item 36.
May it please your lordship. This is against the ex parte interim order. I prefer this appeal, my lord. And by way of interim order, my lord, final relief was granted, my lord.
What final relief was it?
Your lordship kindly see, my lord. And that is one aspect, my lord. Another aspect is, my lord, some misrepresentation of, my lord, fact that is being considered. That is ex parte order, my lord. Page 193, my lord. Your lordship kindly see. May I read it, my lord? Heard Mr. Isare Soli Lanet, Senior Counsel for the petitioner. The petitioner under 24 Gram Panchayat Samabhai Samiti Limited in District of Gram Panchayat and involved in a lifting of distribution of food grain under the National Food Security Act. Petitioner, please put in. Hmm?
Why don't you approach the learned single judge for the
My lord,
this order?
my lord, learned single judge might have taken into consideration of the one division bench order, my lord. That's why I'm before your lordship, because that division bench order, my lord. But the petitioner suppressing that, my lord, they are earlier, it's a second round of litigation. Earlier, my lord, what happened that in the, I'll just place the background, my lord. In 2015, my lord, government of Assam introduced a system that tender process will be adopted for carrying contractor in PDS system. So that was challenged in different district, my lord. From the different GPSS by the different district, my lord. And on this present petitioner also challenged that, my lord, that tender system. That tender system, my lord, judgment was delivered in negative, my lord, that the petition was dismissed. Some of the district, my lord, prefer a retaping. But the petitioner, they did not, present petitioner did not prefer any
He has
retaping.
not preferred any appeal.
No appeal, my lord. So that, my lord, that's why in that district of, my lord, Golpara, that, my lord, tender system is adopted and I am continuing. That was not taken into consideration by. Hmm?
Preferred any appeal. That
Ye-
they have not
yes,
preferred any
yes,
appeal
yes, yes. They
against the
interpret petition,
judgment
they
of
have,
the
my lord.
learned single judge.
They have very technically, my lord, state, yes, they have stated that they have, whether they have filed a affidavit or not, I have annexed their order, my lord, but they have, no appeal has been preferred, they have annexed, they have stated money in the petition. That, my lord, your lordship will find. The petition, my lord, at page 107. There is para 28, page 130, my lord. That the petitioner has not preferred any appeal against the judgment and order dated 21/9/2017. So now, my lord, they are.
Then concept for the appellant. Submitted that. The decision of the state government of awarding tender to the third party or outside to the transporters for transporting the food grains was challenged by the respondent GSS by way of
GPS,
huh?
GPS.
GPSs by way of writ petition before this court. However, the writ petition filed by the respondent GPSs was dismissed on 21/9/2017, whereby the decision of the state government of
No, that is 29/11/2017.
21/9/2017.
That is, your lordship kindly, that is the main judgment. Thereafter, my lord, I have annexed their order, my lord. The petition order is, my lord, page 92, my lord. Page 92, my lord. It is covered by that judgment, that's why, my lord. The
Okay,
29/11/2017.
29/11/2017 कर देना है ना? एक मिनट वापस क्लैरिफाई करवाना। Number, writ petition number 6648/2017. (29/11/2017), affirming the decision of the state government of awarding contract for lifting public distribution system commodities and transporting the same
6648.
by and same to the different gram panchayats. Gram panchayats and the fair price shops under the gram panchayats. Stop. It is submitted that the said decision of the learned single judge has not been assailed by the respondent GPSs at any point of time. And since then, the tender, the contract of lifting the lifting PDS commodities and transporting the same to the fair price shops under the different panchayats is with the appellant
My lord,
since 2017.
since 2017, there are two tender systems, I was awarded, my lord, so I am continuing.
Since 2017. However, the appellants, however, the respondent GPS, without disclosing this fact, has approached the learned single judge, and the learned single judge has stayed the has restrained the private respondent, restrained the state from allotting the transport contract to the appellant after 31/10/2024.
And also liberty was granted to consider their case.
Learned counsel has therefore submitted that once the action of the state government of transport of awarding contract of lifting the PDS commodities and transporting the same to the different price shops at different gram panchayats is upheld by this court. Any interference by the learned single judge is without, any justification. Stop. Issue notice of step, issue notice. Mr. So and so. Mr. So and so is appearing on behalf of the respondent. Let notices be issued to the other respondents returnable on so and so. In the meantime, effect and operation of the order the order dated so and so. In the meantime, the order dated 4/10/2024 passed by the learned single judge in writ petition number 5184 of the 2024, restraining the state respondents not to extend the contract awarded to the appellant beyond 31/10/2024 shall remain fixed.
Deeply observed. My lord, writ petition, my lord, earlier writ petition, my lord, your lordship mentioned as 6648/2017, not 2015, my lord.
2015.
6648/2015,
Just a minute, hold.
page 92. Page 92, my lord,
92,
page 92.
15. Okay, yes, it's 15, 6648 oblique 2.
Deeply observed.
Oh, yeah. Who is sitting for hearing matters?
Worship, we are on behalf of the State Department, in item number 34, Lordship. Worship, I have a small prayer, Lordship, for your Lordship. Lordship, the medical admission matters are happening today. And the last date for medical admission happens to be tomorrow, the 5th. That is why the council who is handling this matter, Mr. B. Gupta, is not here. Lordship, he's engaging in that matter.
You want, today want accommodation?
Yes, Lordship.
Okay, yes.
Well, we do not have,
Yeah.
Other side,
we do not have any objection, my lord. Let it come up next week, subject to your lordship's convenience, my lord.
Would we? Chali, yes, next
Well, there is an interim order operating.
31.
model, if any, to continue till next day.
Obliged.
Yes.
In item number 31, your lordship, I am for the respondent bank. I am praying for an adjournment in this matter.
Yeah. पैसे लेके बैठे रहो